the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5235. Novartis Pharmaceuticals Corporation appellants versus Robert F. Kennedy Jr. in his official capacity as Secretary of Health and Human Services et al. Ms. Stetson for the appellants, Ms. Dan for the appellees, Mr. Lenman for the interveners appellees.
Good morning, Your Honors, and may it please the court. My name is Kate Stetson. I represent the appellant, Novartis. Generic drugs must be the same as the innovator drugs they follow. The same means identical. Everything from their labeling to their active ingredients with limited exceptions. Close enough is not enough. This appeal involves a generic drug application where FDA, in its eagerness to approve a generic, settled for close enough. Those shortcuts it took resulted in the approval of a drug that does not have the same active ingredients, does not have the same label, and does not even have the same dosing regimen. So to start with that last issue, the dosing regimen, in order for a generic to carve out part of a label, FDA must find that such differences, and this is the quote, do not render the proposed drug product less safe or effective than the listed drug. And that requirement has teeth, as we explained in our brief. You can see at Joint Appendix 386 to 389 examples of circumstances where FDA concluded that it was not possible to approve an ANDA because the modified dosing regimen or similar regimen could not be carved out, lest it render the proposed drug less safe or effective. There is a modified dosing regimen on the Entresto label that is protected by a patent. And FDA concluded, regardless, and you can find this in Joint Appendix 354 to 357. This is all of the FDA's response, 6 paragraphs. FDA concluded that it was appropriate to carve out the modified dosing regimen, which pertains to vulnerable patient populations who are so-called naive to certain types of drugs or have taken low doses of those drugs, that it was okay to carve out that dosing regimen because, this is Joint Appendix 354, the warnings and precautions section, section 5 of the labeling, are sufficient to mitigate the risk of Entresto's important adverse reactions. So just to pause on that for a minute, if you turn to Joint Appendix 44, you'll find the warnings and precautions section of Entresto's label. Joint Appendix 44. If angioedema occurs, discontinue Entresto immediately. Monitor for airway compromise. If the larynx swells, this could be fatal, so take measures necessary to ensure maintenance of an airway. Remember, this is a pill taken at home. So these measures that FDA is talking about, that it concluded render the generic product no less safe or effective, are after-the-fact measures designed to take into account an adverse reaction that's already happened. But of course, that's not the standard. The standard that FDA needed to find is this generic product no less safe or effective without this information than with it? And I think the pivot to Section 5 is a real tell. Now, what you find elsewhere at Joint Appendix 354 to 357 is what I believe to be a bit of a sideshow, which is about the strength of the underlying data supporting the inclusion of the modified dosing regimen in the first place. There's a lot of discussion about how the study wasn't very robust, it didn't really show very much. That, of course, I think is problematic for a couple different reasons. The first is it's all after the fact conversation by a different branch of FDA about something that another branch of FDA concluded 10 years earlier. And if you look at FDA's statements from 2015 to 2024, you find a regular drumbeat of support for the idea that this was important to be on the label. Whether it was the safest is not the question. But if you look, and I'll just read you a series of sites. This is from the clinical review back in 2014. Joint Appendix 615, more patients who were naive to those sorts of therapies or on low doses were able to achieve and maintain the target dose of Entresto when up titrated over that longer period of time, 6 weeks versus 3 weeks. That's Joint Appendix 615, that's sealed volume 3. Joint Appendix 619, we believe the key
So are these
risks.
FDA findings that you're reading here? Or
These
from
are
the titration
FDA,
study?
FDA findings, yes. We believe the key risks of hypotension and so forth can be adequately managed through clinical monitoring and dose titration. That's 619. You can find similar statements, I won't read them all, on 621, 623, 626, 627. And finally.
There is dose titration on the MSN label, correct?
There is a recommendation in section 5 of dose titration on the MSN label, but I think there are a couple problems with that. The first
Sorry,
is,
I'm looking at JA67 and it has starting, second, final dosages, titration doses on there. So, right?
right, and
So it's
and-
titrated too.
it's titrated for other circumstances. It does not say, and it can't say,
Mhm.
for people who are ARB or ACE naive or have taken low doses of those, titrate in this certain way. I think there are other examples, renal
Because
impairment.
that's your patented.
I'm sorry?
Because that's your patented.
Because
titration
that's the
thing?
patent, exactly. That's the
It does have
667 patent.
titration, so the issue isn't titration.
No, the issue is titration with respect to those vulnerable populations, Judge Millett. The fact that there is titration recommended in other circumstances, I don't think answers this question. And I don't even hear FDA making that argument. The fact that a practitioner might up titrate for certain other circumstances doesn't mean that you can take out this information from the generic label and declare it to be no less safe or effective, which is, when you pause to think about that language, a very rigorous standard. What FDA appears to be saying here is we don't know that it's the safest to up titrate in this particular way. Therefore, we can comfortably conclude that it's no less safe if we take it off.
Well, that's not just that, because they also concluded from the original titration study that there were other patients. I mean, one, it was a very, very small population that was studied and had other factors that made it a not so reliable study. I mean, it'd be helpful or informative, but not controlling didn't have sort of controlling reliability in that way. And they did have patients who were not being titrated in the same way and found no material difference in results.
Well, I think, Judge Millett, that
I mean,
could be,
am I describing it accurately?
I think you're describing it accurately to the extent that you've described it.
Mhm.
But the other thing in the study, among other things that I read to you, is more patients who were naive to those therapies were able to stay with and achieve the target dose by being up titrated more slowly. And that actually squares with something that FDA even acknowledged in its citizen
This is
petition response.
pretty narrow, scientifically focused arguments here that you want us to say is that, well, they didn't quite analyze the evidence from the study this way when they read it that way. And it feels to me that that's a hard row for us to hoe.
Oh, no,
as specialists here.
I actually.
Non-specialists here, not very, at least me, very
Not specialists in this
here.
area. Yes, like all of us aren't. But it's actually not narrow or scientific at all. It's a question about what the regulation required. FDA must find that this generic with the carve out is no less safe or effective.
And they made that finding.
They made that finding,
Okay.
but
They made that
important.
finding based on the fact that the whole titration regime had been studied, and what they essentially concluded in 2015 was fine to do it. Maybe it helps a little bit or not, but it's fine. It's not harmful. If you want to do it, do it. But other people without titration, they're doing just fine, and we have some titration here. And so what you want us to do is sort of like get into the weeds and say, well, you didn't titrate exactly the same way for this particular group of folks. And again, that just feels like not in our wheelhouse.
No, I actually don't. What I suggested is that all of this discussion about the titration study is a bit of a sideshow because that is not the job of a generic approval. The job of a generic approval is to say, is this thing the same? Not to go back and look at why something was put on the label in the first place. All of this is a discussion that could have happened in 2014 about why this modified dosing regimen should go on the label, but it's on the label. And once it's on the label, in order to take it off, the FDA needed to conclude that it was no less safe or effective. And that's why I keep pointing to the because clause. The only why and I think this is a good question to ask FDA counsel, why was it, no less safe and effective? And the only because is Joint Appendix 354. The omission would not render these drugs less safe or effective because Section 5 takes care of it. All of that stuff about the titration study is just designed to try to minimize the titration study, which puts something on the label in the first place. And I don't think it is a logical flow to say the study was not robust. It showed certain things. It showed that people tolerated this drug better over a longer period of time, but it wasn't sufficiently robust. Therefore, we can't show that it was the safest. Therefore, we can't conclude that it's no less safe. Therefore, it's no less safe. That's the logical line that they're asking you to pursue. And that simply doesn't hold up. That's not a matter of science. That's a matter of freshman year logic.
It's a matter of the agency's reasoning. I mean, they make the necessary finding, would not render the drug less safe or effective. And then part of the explanation why is that the benefits of the alternative dose, as reflected in the titration study, are pretty equivocal, pretty minimal, like not worth a huge amount. And I mean, it makes it a little bit odd that they approved it on the front end. It seems to me like it's not necessarily unreasonable for them to say the basic dosing is safe and effective. There's one study that doesn't really move the needle much one way or another, so we don't really care. It's safe. There's no reason to think it's different. It's safe. We approve it.
Yeah.
And now on the back end, they're looking back at it and saying no less safe. Those two things are consistent, and seems like your line of attack goes more to saying maybe they shouldn't have approved it on the front end.
Judge Katsas, I don't think those two are the same at all. And I think even the way that you were describing it kind of shows the flaw in FDA's
The
reasoning.
front end and the
The
back
front
end.
end and the back end. I mean, what you're basically saying is,
That helps FDA.
it does not. What you're basically
On
saying
the
is,
front end, they say
on the front end, they say,
it's
safe.
safe.
It's this may help because people tolerate it better. Therefore, we believe that this is appropriate from a safety perspective. You would have to kind
Did
of
they say
do it.
because people tolerate it better?
Yes.
Because it appears that some people in this group did, but others who didn't have the titration did fine too.
Well, now we're really getting into the science though,
So-
right, Judge
I
Millett?
know,
Because
I'm
what
just
they,
reporting what
Right.
that is. I don't know how it happened.
Right,
I don't
and-
know the
but
chemistry of it.
what
But there was a control group that wasn't titrated and they did just as well.
what FDA said at the time, not in 2024 when it was looking to approve the generic, but in 2014, 2015, more patients who were naive to these previous therapies were able to achieve and maintain the target dose when up-titrated over that longer period of time. We believe the key risks can be managed through monitoring and dose titration. A longer titration period may reduce the risk of these key adverse
May.
effects. And that goes to Judge Katsas's point though, right? Because all of this is saying, well, if the evidence is equivocal, maybe it shouldn't have gone on the label in the first place, but it is on the label. And once it is on the label, it is not enough to say, well, it was safe, maybe safer if, because it was on the label. So now we can conclude that it is no less safe. Those are the three words they need to conclude. And that you can't do by saying, but the study was not really robust and it showed that certain people didn't really have an effect and certain people did. All of that is the quintessential kind of post hoc equivocation. This was on the label. You have to start from that premise.
Suppose they thought on the front end that the alternative dosage was equally safe as the approved one. They could have approved that on the front end because it's safe. And they could have approved this on the back end because not approving it doesn't make it less safe. Just a wash.
I think, Judge Katsas, the critical word in your question is suppose. Suppose they concluded that it was just as safe without. We don't know that. We have FDA telling us 10 years after the fact that the study really wasn't worth much. But the fact on the ground that we all need to start with is that this was on the label. And it was on the label because of all
But
of those
we're
sites.
reviewing this order, which says it's okay to take it off.
Yes. And I think the question for
Not
the court is,
Not whether it was okay 10 years ago to put it on.
right. It's okay to take it off because we, the FDA, conclude this is no less safe or effective. It is no less safe or effective because Section 5 does all the work for it. That is the problem. All of the talk about how good the study was, how bad the study was, is just, I think, kind of accessorizing what FDA's actual conclusion was. So in order to find that this drug was no less safe or effective, you have to accept FDA's representation that those treatments for adverse effects, the larynx closing, the high blood pressure, the renal failure, after the fact are all sufficient. Now, I know my time is up. I'd be happy to address either of the other two issues.
I have at least one question on this topic.
Sure.
Should we be worried that if we agree with you here, it will provide a disincentive to the FDA next time they're deciding about whether to put something on the label on the front end?
I don't think so. In part because, as I understand the makeup of FDA, these are different groups doing different jobs. The group that is doing the front end job is deciding whether something should go on the label, whether it shows that there may be some upside, that these groups of patients did benefit from a slower regimen. The group of people who are deciding whether to approve a generic are looking essentially for one thing. Is this the same? Is it the same active ingredient, same labeling, same dosage regimen, except for these limited exceptions?
But
So
that-
I don't, sorry to interrupt, Judge Walker.
I interrupted you.
Yeah. So I don't think that this conversation about whether FDA hit its regulatory mark here is going to impact the office of CDER, the new drug approval in the first place. I think that if something belongs on a label, they will conclude it should go on a label. And if it's on the label, then the generic drug office needs to conclude that it is no less safe or effective for it to be off. So I don't see those two
I
happening.
think that's responsive. Let me give a hypothetical, but I think your answer may be the same answer. Now it's 2026, the year 2026, and that first office you mentioned is called CDER.
Yes.
Okay, CDER's, they're deciding what to do with the very inconclusive study. It wasn't designed brilliantly, doesn't show a lot, but they think, it couldn't hurt to put this titration warning on the label. Might not help, but we're certain it wouldn't hurt. So when the costs are zero, it's an easy decision to make, even if the benefits are minimal. But if they know that down the road, making that decision is going to keep generic drugs off the market, which will mean fewer people can access this medicine because not as many people will be able to afford it. Now you've really raised the cost of putting that warning, that titration information on the original label. And so they might say, okay, well, originally there was no cost, minimal benefits, let's put it on. But now we know they're quite significant costs, still minimal benefits. So we'll just keep it off in the first place.
I think my answer is the same. But the reason it's the same is because I think the solution to that is for FDA to amend the regulation. If it wants to create kind of a broader aperture for approval of a generic drug product, it could attempt to amend the regulation. I think it would run into the statute at that point.
Why would
because-
CDER not think? And what I described, are they not allowed to think in those cost benefit terms?
I don't know that CDER would consider it to be its job to think about those policy type costs down the road. I think what CDER, none of us can really channel, but what CDER would likely say is our job is to approve this drug and this label if we conclude the drug product hits certain marks. If the label really were like, can't hurt to put it on, and there's no showing of any benefit, I'd venture that it probably wouldn't go on the label. anything could go on the label. This went on the label because the people whose job it was to approve the label concluded that there was something worth putting on the label. And in that instance, I think it's not appropriate to ascribe to Cedar some forward-looking, generic-facing 10 years down the road problem with what it might be approving.
I have a question about a different topic.
Just follow up on that real quick, is that okay? How does this labeling process work? Does the company, Introso here, first propose a label?
It
And they
does.
go through, right, so, and Introso here, I assume, proposed a label with this titration process on it, correct?
It does, yes.
So, I mean, it wasn't, this titration issue that you're talking about here wasn't something the FDA came up with itself. It was, Entresto proposed it, and it looked and said, I'm sure they're looking for all kinds of accuracy and stuff on these
Right.
labels, and they said on titration, they said, we obviously got to make sure nothing on the label makes it less safe. And so Judge Watchwood was suggesting, they looked and they said, you know, a spoonful of sugar makes the medicine go down, fine, you can have it on there, it's not going to make it less safe,
Mm.
right? It's on, right? Is that
No,
right?
I-
They approve it because you proposed it and your proposal didn't, you know, was consistent with was consistent with a safe way of administering the drug.
I don't think that's the standard at the time, Judge Millett, and I certainly don't think that's what they
Okay,
concluded.
what is their test? So you come in with your label, it has this titration. Let's assume everything else has been signed off on. What is their test for whether that titration regime should be on the label?
Does this label, does this dosing regimen represent a drug that is safe and effective for its intended
Okay,
use?
right,
Is
so
this
it's
safe
safe.
and effective?
Right.
Yes, but
Your titration thing is not unsafe.
See, I think there's a lot of mischief in saying not unsafe, because I think what FDA actually
But
said,
it's not the same thing as saying it's safer. I mean, your argument seems to be that it is safer, that titration regime, but that is not, you all proposed a titration, not them. They didn't make an independent finding that this has to be on there. It's required to be on there to make the drug safe. You all proposed it and they said it is safe with that titration regime.
a couple
that
of
what they did?
responses, a couple of responses. The short answer is no, it's not what they did. The two responses are, first, there's no hierarchy with which I'm familiar between putting something on the label because it's super, super safe and because it's somewhat safe. What FDA actually concluded, Joint Appendix 623, we agree from the proposed titration strategy from a safety perspective. Joint Appendix 627, the titration study was relatively small but supports the proposed scheme. Patients who are naive to ACE inhibitors or ARBs on low doses should use a lower starting dose. Joint Appendix 621.
That just means titration, right? So it's safe.
Yes.
It's safe. They didn't say this is the only way to make it. They found, here's what you guys want to put on there. We've looked at it. It's safe. Your titration regime is safe.
But-
That's what it sounds to me like you just said, what I said. I
It
mean, and
may.
it's either safe or not safe. And they found it was safe.
Well, I think the reason I'm hesitating, Judge Millett, is because we don't need to characterize how exactly FDA found it to go on the label. What we need to do is figure out whether FDA correctly found that it could take it off. And that
No,
is
but your
subject,
argument is it was on the label.
yes.
And so taking it off necessarily makes it less safe. And I don't think that's true. I think they could look at your proposed label, look at your titration information and go, it's safe. And someone could come along with another label for a generic and say, here's what we're doing and here's our titration approach. And they could look at that and say, that's safe too. You're kind of dividing the world into sort of this sort of in or out. It's all or nothing. It's either safe or unsafe. And I don't understand why they couldn't both be safe, and a finding that your label was safe, that you proposed with your titration regime, necessarily means that any other label that doesn't have that won't be safe.
So
will be
Judge
less
Millett,
safe.
there's two different strands, I think, of your question. One of them is Novartis certainly argued that taking this off the label would make it less safe. That's certainly
They
the
may have
case.
argued that, but that's
But-
not what the FDA found. Wait,
But what
one thing at a
FDA
time.
Yes,
Am I accurate in that? FDA did not find that.
FDA did not find that.
Okay.
And what the sole issue here is not sort of what Novartis thought, though. It's what FDA concluded, because FDA had to conclude that taking it off would make it no less safe.
Mhm.
Not safe, not safe-ish, not safe as long as we can cure somebody's airway closing after the fact, no less safe. And that is the problem.
Mhm.
The problem is because FDA had to hit that very high mark, which is understandable because we're talking about approval of a generic drug that has to be the same.
Mhm.
Once it's on the label, that analysis changes. We can talk for a long time
Mhm.
about why it went on the label, how strong it was, who got a benefit and who didn't. But once it's on the label, what FDA has to conclude when the Office of Generic Drugs picks up the pen is this the same? Can I take
No,
this
is
off
it
without,
less safe?
is it no less safe?
Yes.
Are these
Sorry, I don't
things
know the difference between less safe and no less safe, but I'll take your formulation if you
no
want.
less safe?
And so they found that here, and they gave a reasoned explanation for it.
I think that's where you and I differ, Judge Millett,
Okay.
because they certainly found it here. And the sole issue on this is, was the explanation reasoned? Was the explanation reasoned when they say it would not render these drugs less safe or effective because Section 5 is sufficient to mitigate the risk? That is the conclusion. That is the only because that they offer. And again, not to beat the dead horse, but all of this discussion about how strong or weak the titration study was in 2014 is beside the point because, Judge Millett, as you pointed out, this is on the label.
Mhm.
And because it's on the label, that's the because that they have to establish. Why is it no less safe or effective? Because Section 5 does all the work? Because after the fact, curing of adverse reactions and stopping somebody from taking this drug or lowering their dose at that point does all the work? That can't possibly be correct.
Right, but if we read the label as having titration up front.
Well, I think this is an FDA argument that because the label references clinical judgment and titration, there's really no harm, no foul in taking this specific titration method for people who are naive to certain types of drugs that expand your blood vessels. That a doctor could look at that and say, I'm going to take this a little bit more slowly.
Did they
But that's-
find that your titration regime precluded these other health risks?
No,
No.
I don't think they
So
did.
either way, there are these risks of things that will happen when they take the pill at home, of hypotension, renal issues, other things. These risks are going to happen with either label.
They are going
Right?
to happen less with the slow up titration label. That was the point
now
of the,
what we're all the way down to here is a scientific judgment whether those side effects and they're not dealing with the complete same population that you all are for your drug.
Right.
So they're doing a subset. And as for that group, we have to say they wrongly found that there would be a equivalent risk of side effects on the titration regime on the MSN label.
no,
Because unless there's evidence that there will be more frequent for the population the MSN drug is serving, more frequent of those dangerous side effects that are hard to deal with at home on the titration regime that's on the MSN label than on your label. Unless they make that factual scientific finding, then they're correct. That
I think they have to make the exact opposite factual finding, Judge Millett. They have to conclude, it's their burden, to show that this is no less safe or
Right.
effective. So what they would have to conclude is there will be no more adverse effects. Nobody being taken off this drug prematurely because their larynx started to close or their blood pressure spiked or they had a renal failure. That would be no less safe or effective, but not one person without that particular modified dosing regimen would suffer an adverse effect. That's the evidentiary standard, not our burden, theirs, and they have to show no
And it is
less safe
for
or effective.
one person is the test?
No less safe or effective.
For
Yeah.
one person?
I
sort of
think we
if you have sort of
We could have an
a
interesting
super
debate.
vulnerable one, but
If
I
they
don't think
came
that's a
in-
proper addition.
If they came in with new evidence, and one of the remarkable things here, of course, is there's no new evidence. Counsel for the government conceded below that this is the same record they were working with in 2014. But if the agency were to come in hypothetically and say, look, we've looked at this and we've studied the evidence, and we think that out of 10,000 people taking this drug, one person without this warning might suffer an adverse reaction, then we could have an interesting conversation about whether that was supported by substantial evidence. That was not their conclusion. Their conclusion was, we think this is no less safe or effective because you can figure out the risks after the fact. That
Well, just
cannot
that
be
with
correct.
the dosages and warnings that were on there, and the dosages include titration. You gotta be fair to what.
The dosages and warnings that are on there, I mean, this is another thing that FDA says that is kind of interesting, that they say, well, there's references to up titration in section 5. One of the things they say is if you have an instance where somebody starts swelling up or has a high blood pressure, you can titrate, drop the dose and titrate up from there. But FDA's own regulations say that any dose modification, this is 21 CFR 201.57 C3, Romanet 2, dosing regimens must not be implied or suggested in other sections of the labeling if not included in section 2. So that is the issue I think FDA is confronting. They are trying so hard to get a generic on the market that they are basically passing this off to the warnings and contraindications section rather than putting this where it belongs because they can't find on this record that it can be taken off the label without rendering this no less safe or effective. Now, this does not leave either FDA or the generic in a bad spot. Judge Walker, you asked about possible adverse impacts down the road. FDA can change its regulation. The generic also had a choice here. The generic applicant could have done what about another dozen applicants have done and filed a paragraph 4 certification to the patents that we're talking about and duped it out in patent litigation. But these folks decided they wanted to try to carve a bunch of things out, including the indication section that we haven't talked about, and try to jump the line to get in front first. That works if FDA hits its marks, and neither on the dosing regimen generic is composed, just as the artificial sweetener is not the same chemical form as a cube
So
made up of granules.
So it sounds like it might actually be a very, very accurate analogy. And your argument is in FDA world, the difference between sugar cubes and granular sugar does matter.
Matters. It matters, yes.
So one other quick question with this ongoing patent litigation, I guess, in Delaware.
There is, yes.
And is there any chance that that litigation is going to affect whether this remains a live appeal?
I don't think it affects whether this remains a live appeal because the patent litigation has to do with the applicability of a particular couple patents that I don't think are squarely at issue here. This case,
But
of
if they
course,
were to-
involves,
If that, it's against MSN, I know like the pediatric applications are going on there, I believe, at least part of it. If that court were to decide
Yeah.
that MSN can't go on the market because of patent issues, wouldn't this all become a moot question here?
I don't think so. The patent, if I remember correctly, that's at issue in the Delaware litigation has to do with it's a 659 patent. It's combinations of sacubitril and valsartan. If the court were to conclude that the patent is valid and, has a particular patent life, the issue here is whether MSN should have been approved at all because it doesn't, it's not susceptible to having those carve outs that we're talking about or the two active
I
ingredients. that
understand,
I'm
but would
talking
it be able to go on the market at all? I mean,
No.
The point here is can it go on the market? You have issues about whether it should be allowed to go onto the market, whether it should have been approved under this exception for different indications, or carving out indications. But if, I'm asking it, I'm trying to ask a simple question, but maybe I'm failing in doing so, and that is, if MSN is found to have violated patents on this drug, Entresto, in Delaware, would that not keep them off the market, regardless of how we answer the questions here?
I don't think it would. I'm
Okay,
happy to
because-
send a follow-up letter if it would be helpful, just laying out the
Mhm.
current state of play.
Mhm.
But I think it would not, because one is an issue of timing and the other is the issue of whether this should have been approved in the first place. And I
Whether
think those are,
MSN
yes,
drug should have been, right, but if
generic
it shouldn't have been, that's my point. If they decide it shouldn't have been approved in the first place for a different reason, it would root out these issues.
I
And
think
I
that-
mean, you all stopped the litigation here in this district court to wait for what's going on in Delaware, which suggests that there is some relationship.
there is some relationship between the current district court litigation and the Delaware litigation,
Mhm.
yes. But shouldn't have been approved in the first place is different from can't be marketed until the patent runs out. I think that's the problem. One is timing, one is whether it should have been approved in the first place. But I'm very happy to follow up with a letter just so you've got it in front of you.
Any
There are no
questions?
further questions.
Thank you very much.
Thank you, Your Honor.
Good morning, and may it please the court. Caroline Tan for the government. Congress wanted to make it easier for affordable, life-saving drugs to enter the market. Pursuant to that scheme, FDA approved a generic version of Entresto that lawfully carved out patent-protected portions of the labeling. FDA also applied its scientific expertise to determine that the active ingredients for the two drugs are the same. The district court upheld FDA's approval in a thorough opinion. This court should affirm that decision. I want to start first with the 2.6 dosage labeling. I think the critical point to realize in assessing this issue is that FDA had to answer two different questions in deciding whether to approve the 2.6 labeling in the first place, and then in deciding whether carving out that labeling, whether or not that would render the generic drug less safe or effective.
Can you just speak up a bit? I'm having trouble.
Yes. Yes, Your Honor. In 2015, when FDA had to decide whether to approve the labeling in the first place, FDA only had to ask whether or not the drug was safe with the labeling, not whether that particular specific quantitative dosage mechanism made the drug more safe or was necessary to maintain a particular level of safety. That comes from
To
the
decide if
statute.
it's the only safe way?
No, just deciding whether the drug is safe with this labeling. That was part of FDA's overall review of the new drug application, which included that 2.6 labeling.
If FDA in 2015 believed everything they've said here about just how weak and equivocal and flimsy the titration study is, seems odd. Would they have approved the alternative dosage?
So
Seems odd.
the question before FDA in 2015 was whether the drug as a whole was safe. That 2.6 labeling was included as part of the new drug application package. And so FDA was assessing the application as a whole. And at the time, FDA had determined that the titration study, which underlies this particular dosage mechanism, nevertheless made the drug safe, but never said that that particular regimen made the drug more safe. And, I'm happy to
That
talk in
regime
more
made it
specifics
safe,
about,
or it was safe with that regime?
it was safe with that regime.
That's different than that regime made it safe.
I only meant in considering the application of that particular study, but yes, the question is whether or not the drug was safe with that regime. The question in 2024, however, when FDA was deciding whether or not the carve-out made the drug less safe or effective, is a different question. The question at that point is whether or not, it requires the FDA to consider this particular regimen in isolation and to evaluate whether or not it was less safe or effective, even if you carved that regimen out. And at that point, FDA concluded that the carve-out did not render the generic drug less safe or effective, in part because the underlying study that supported the regimen never demonstrated that this particular dosage regimen was necessary to maintain a particular level of safety or made the drug safer. I'm happy to talk about the study in more
What about, they
specifics.
talk about certain patients who naive or certain conditions or whatever, for whom the slower titration did seem to work better.
Right. So one of the reasons that FDA determined that the carve-out was okay in this instance is that the underlying titration study already evaluated people who had demonstrated some level of tolerability to Entresto. And so it wasn't a population that was necessarily ARB/ACE inhibitor naive, which was the particular population that the dosage mechanism was referring to. FDA also said in its, at JA 355 that it is unknown whether initiation using this dosage regimen would lead to a meaningful difference in adverse side effects, including hypotension, impaired renal function, and hyperkalemia. And that because there was no evidence supporting the idea that this particular dosage mechanism was necessary to maintain a certain level of safety, carving it out was fine. It would not render the generic less safe or effective. I also want to flag that FDA made this decision in light of well-known background medical guidance in which dose reduction is a known mitigation strategy. So it's not as if, so in either world, there is an understanding that medical providers recommend dose mitigation for these types of patients. That was a reasoned finding. And the question really here just comes down to whether or not FDA applied its own regulation as to a technical determination that is within FDA's expertise. And I think the record more than adequately meets that standard. I'm also happy to talk about any of the other issues if this court would find it helpful, but otherwise, I think that FDA's determination on the carve-outs as to the indication use and the labeling here adequately more than meets FDA standard, and the active ingredient issue is clearly the type of scientific determination that's within the agency's expertise.
Is the generic here a co-crystal or not?
The generic is, I don't think that okay, two responses, Your Honor. The first is that amounts to a physical distinction, and there's no dispute here
No, I
that
understand they don't. I'm just sort
the
of.
regulation.
At some point I got confused and I thought there was illusion that it could also be considered a co-crystal. I'm just trying to clarify that.
I think the answer is no, Your Honor, but I don't think it matters because the regulations refer only to chemical identity and not physical form. And the plain face of both drugs labeling make it clear that they're composed of the same atoms, same molecules.
And back on the labeling thing, the explanation is that the titration study showed that the titrating regime might be safer, at least for the naive patients. So didn't FDA have to do something more at this stage to decide that in fact it's not safer? Why is finding something might be safer and then going, this one's safe without it? It just feels like there's sort of a gap there without having made an affirmative determination that in fact they're not safer with it. That's how you would decide that the MSN drug is equally safe, no less safe.
So I think the answer is because there are two different standards that FDA has to apply in evaluating that what it did in 2015 and what it did in 2024. And when it approved the drug application in the first place in 2015, the question under the Federal Food, Drug, and Cosmetic Act, this is in 21 USC 355 D2, is whether or not the drug is unsafe for use, whether or not the results of a test show that the drug is unsafe for use under such conditions, or do not show that such drug is safe for use under such conditions. And so when translated to plain English, that means whether or not the drug is safe with the 2.6 labeling. That's a different question. And at that point, FDA, in 2015, FDA said, yes, there may be some.
It might be safer, at least for this subgroup of naive patients.
Well,
I'm
FDA
just
did
trying to
not.
figure out how, when you have at least that might be safer, you can decide that something that doesn't have that is equivalently safe without answering that question as to whether in fact it was safer. Am I
So-
making any sense? There might be a something.
Yes, only in as much as it explains why FDA approved the new drug application with that labeling in the first place. But at no point did FDA say that that particular dosage regimen made the drug safer. It just said the drug was safe with that regimen.
I said it might be safer.
So I think you're referring to JA 355, where FDA explained.
Yeah.
Is that right?
Yes, the bottom paragraph there.
Yes, as discussed above, titration was a supportive phase 2 trial and suggested that certain patients might benefit from a slow up titration regime with a
Mhm,
lowering
right.
starter dose.
Right, might benefit. So is that seems, it might be safer. Is that wrong? Am I reading that wrong? Patients might benefit mean it might be safer for those patients.
No, I mean, the question is, so I don't want to divorce, I think, this isolated sentence from the regulatory standard that FDA had to put. The question that FDA answered in 2015 was whether the drug is safe with the regimen. And FDA said
Understand.
the drug is safe.
I
in part.
understand that, but then now we're later and they have to make sure there's an equivalent level safety. They can't be any less safe. So I'm calling that equivalent
Correct.
safety, equivalent or better, I suppose.
Whether it's necessary, yes.
Right, no less than equivalently safe. And I guess I'm gonna try it one more time. If they say there was some evidence that it might be safer, at least for this one group, to have this titration regime. And now it's 10 years later and you want to go, we don't need that. Don't you need to eliminate that possibility that it might have been safer?
Well, FDA actually determined that it was not, that there were no meaningful differences in adverse side effects between these two sets of populations. So I think when we talk about safety, Novartis refers to that in terms of the side effects of hypotension, hyperkalemia, and impaired renal function. And FDA actually determined just in the sentence before the one that we were talking about, notably the rates of hypotension, renal dysfunction, and hyperkalemia observed in titration were similar between the two groups.
Except the next sentence, might benefit from a slow titration regime, blah, 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 to reduce the risk of adverse reactions such as hypotension, da, 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 da.
Right, and therefore the drug was safe with the proposed dosage regimen that Novartis had suggested be included as part of the Entresto labeling. But that is a separate question, once again, from the question in 2024
Would it
about
be-
whether or not omitting the
Would
regimen.
it be okay to think about what they did in 2015 as saying it might be safer? We know that we don't know whether it will be safer.
The test is whether, I'm going back to the statute, is whether or not the drug is safe with that labeling. And so I'm not sure if I can say that it'd be okay if FDA said we don't know, but that's not what FDA said here. FDA said it's safe with the labeling in part because of these potential benefits. But
Well,
FDA never
they knew
determined
that it
that.
was safe
Correct.
to put the drug on the market. I get that. And then they added this thing about the dosing regimen. And they said, this particular warning, this particular dosing regimen might benefit some people. And I'm wondering if they could have believed everything they believed at the time and instead issued a statement saying, we know that we don't know whether the dosing regimen will benefit anyone. It might benefit some, but it might not. It's something we don't know.
So there's two responses, Your Honor. The first is FDA considered the dosage regimen as part of the overall new drug application process. So it wasn't this two-step thing where they said, oh, the drug is safe, and oh, let's look at this regimen separately. That was part of the overall drug application. And FDA made this determination in light of the understanding that doctors know to use dose reduction as a mitigation strategy, regardless of whether or not, this 2.6 labeling is there or not. It's well-known background medical guidance that doctors who are treating heart failure patients might introduce patients who are new to a new kind of drug more slowly.
I just
And
want to
so-
make sure you haven't talked me out of agreeing with you. So they could have said in 2015, we know that this modified dosing regimen will make people safer. They could have said that, right? And they didn't say that.
Correct.
And the fact that they didn't say that means instead of saying, we know that this will benefit people,
Yes.
the implication of not saying that is, we don't know if this will benefit.
Maybe, maybe not.
I think that is a fair way to read what happened. I am just somewhat focused on this particular test that applies, but I think that that is a fair way. And it's certainly true that both positions in 2015 and 2024 are entirely consistent with one another.
Do you have a response on the implications of the patent litigation for this appeal?
So I would defer to the private parties on the impact of the patent litigation. The government is not a party to those. It involves a patent, not an issue here. So we defer on the relevance of that particular litigation. Thank you.
Thank you. Council, we'll hear from Council for MSN.
Morning. May it please the court, Chad Lehman from Polsinelli on behalf of the MSN interveners. So starting with where we left off on the dose titration, counsel for Novartis argued and agreed that really what this issue comes down to is, did FDA make a reasoned decision? This is not about the legal standard. This is whether FDA made a reasoned decision. And here, the administrative record can't be any clearer. There are over 300 pages dedicated to FDA's analysis of this issue. Not only do they review the titration study, and that's at Joint Appendix 263 to 272, FDA reviewed hundreds of pages of additional scientific articles. We can see those at Joint Appendix 263 to 894, 895 to 931, and 494 to 519. They also had multiple internal consults with physicians and scientists within FDA, and then issued a 45-page decision in the citizens petition. This is the epitome of an agency making reasonable decision-making, and this is a highly technical issue of safety. Under the law, this court should defer to FDA's decision there. I did want to hit a couple of the particular points that were addressed and the discussion that the court just had with counsel for FDA regarding Joint Appendix at page 356 about the language about might benefit. So there was a discussion over the language about might benefit, and I want to point the court to the next sentence that follows there. FDA then goes on to say, therefore, while titration supports the dosing recommendation in section 2.6 for ACE and ARB naive low-dose patients, and this is the key, and I'll quote, it does not provide a scientific basis to conclude that the standard dosing regimen puts patients at greater risk of adverse reactions. And that's the key here. FDA evaluated the study, evaluated at the time whether removing it would create a label that was less safe, and said it wouldn't. And also FDA discussed again on Joint Appendix 356, looked at the data that counsel for Novartis was talking about regarding dose titration and tolerance. And what FDA said is the p-values in that data didn't support any conclusions. And again, from a scientific perspective, that's important because what p-values relate to is whether something is meaningful, whether it has statistical scientific evidence. And FDA concluded that it didn't. And again, this court should defer to FDA's scientific decision on that issue.
If we
Finally,
were just looking at this decision in a vacuum, suppose I agree with you. But to what extent do we have to evaluate the FDA's current explanation in light of what it said and did when it approved the label, the original label? Does that create a Fox versus FCC kind of change of position situation where they have to openly acknowledge and justify a change? Do we need to look at that?
I don't believe it does, Your Honor, because there were two different analyses going on. When they approved the label of Entresto's label with the dose titration, they were looking at the label as a whole and saying, does the label as a whole render the product safe and effective? And concluded, yes, the label and the administration according to the label would be safe and effective. It's a
Primary and the alternative were approved at the same time.
Yeah, exactly, the dosing rate, exactly. So then now jump ahead to 2024 when they're deciding, do I approve this generic? And the standard, as we've been talking about, is would the label be less safe or effective? And that's a different standard FDA is looking, a different lens it's looking at it through. And that's why it's not contradictory to first include the language in the label and then later say removing it doesn't cause any sorts of issues. I just wanted to touch on briefly, there were a couple questions on the same active ingredient that came up. First, Judge Millett, you had a question about whether the MSN product was a co-crystal. FDA has determined that it is a co-crystal, and I'll point the court to Joint Appendix 813. FDA does an analysis there. Also Joint Appendix 817. Where FDA actually looks at X-ray diffraction data, again, a highly scientific analysis, but determines that the MSN and a product is a co-crystal. Judge Walker, you also had an analogy. I thought it was an interesting analogy of cubes versus granular and whether that makes a difference. Not addressing necessarily the way Novartis' counsel answered your question, but the key is, for FDA's purposes, it's whether the ingredients are chemically the same, not their physical form. So FDA has been clear, and Novartis doesn't challenge that you can have different what we call polymorph forms, which is a different physical form of an active ingredient. In fact, you'll see throughout the record references to the polymorph form that MSN has. But I believe under your analogy, the granular sugar and the sugar cubes, if they're just stuck together in a different form, then they are the same active ingredient. And really, the active ingredient analysis here should begin and end with the label and how FDA describes both products. FDA describes both products, both Entresto and MSN's generic product. They describe the active ingredient as being anionic forms of sacubitril and valsartan and sodium cations in the molar ratio of 1 to 1 to 3. Now, again, highly scientific and complicated, but what FDA is saying there is these are the exact same chemical compositions that are in these products. And again, that's sufficient for FDA making its determination. And again, it's a highly scientific determination. There are hundreds of pages.
What's the language in either the statute or the regulation that I could go to and I read this and I say, okay, in FDA world, we actually do treat cubed sugar and granular sugar the same.
So there's a guidance, a polymorph. So backing up, the statute talks about the active ingredients being the same. Obviously, Congress has kind of looked to FDA to kind of define that more further. There's then a FDA guidance on polymorphism where FDA discusses what polymorphs are and that you can have a different polymorph form. I don't have the citation off the top of my head, but we can certainly submit it later if that would help the court.
Is it in the brief?
It should. Yes. No, there's a discussion in the brief about that.
Isn't it in the regulatory definitions of active moiety and salt?
Mhm.
It's laid out there.
There is as well. Thank you, Your Honor. Yeah, there's in the regulations, they define the active ingredient by the active moiety and including its salt. So not only the active moiety, but the salt forms need to be the same, which again, FDA did a thorough analysis, spent hundreds of pages in the administrative record going through this to make the scientific conclusion. Unless the court has any other questions, want to thank the court for its time and urge the court to affirm the district court's decision.
Counsel. Ms. Stetson, I think we used up all your time, but we will give you 2 minutes for rebuttal.
Thank you, Your Honors. Judge Katsas, I want to start with your question about the Fox versus FCC issue, because as I listened to counsel's arguments, it struck me that there's really two levels of post hoc discussion going on. One of them is actually the classic Bowen versus Georgetown Hospital, which is what you did not hear from either of my friends on the other side, is any reference to the actual because reason that was in FDA's citizen petition response. This is no less safe or effective because Section 5 takes care of everything. That was the conclusion, and you did not hear one word about Section 5 today. What instead you heard was discussion about, again, the titration study. But that gets to your question, I think, Judge, about the nature of the analysis that's going on 10 years after the fact compared to what was actually going on at the time. So you heard a lot of quotes from Joint Appendix 355 and 354 and 356, all of which I encourage you to read, all 6 paragraphs of the reasoning, not 300 pages, 6 paragraphs. But if you go back to the actual Joint Appendix pages where FDA decides and makes its clinical and pharmacological view of this label, Joint Appendix 615, 619, 621, 623, 626, 627, what you will find there is many different versions of this might help people who are ARB or ACE naive.
Sorry,
We've-
what's on those pages? I had the key for the labeling
Sure.
issue we've been discussing is roughly 353 to 356.
That is
Are
the
you-
citizen petition response. That's the 2024 citizen petition response. What I'm talking about is the 2014 actual.
So the original. the
Exactly,
reasoning.
the original
Yeah, okay.
review. So to your
And what's
point
the
about,
page range? Sorry, give me the page range
so
again.
sure,
Just
615,
roughly.
615 to 627. And on each of those, you'll find actually Judge Millett and Judge Walker, some version of what you said, which is we agree that these key risks can be managed through clinical monitoring and dose titration, 619. We agree with the titration strategy from a safety perspective, 623. 627, patients who are naive should use a low starting dose. Mandatory language, by the way, not a recommendation.
Well, they do
If I-
on this label. The MSN label has a lower starting dose too. And what you don't have, and that's what is on 356, is them just flatly rejecting the argument that it's a scientific matter. Your Entresto's titration regime is necessary for safety.
I know my time is up, Judge Millett, but if I could just respond to that quickly. If you look at that paragraph on 356, which I encourage you to, FDA is essentially setting up the straw man of what Novartis argued. Novartis argued that the modified dosing regimen was the safest and best tolerated regimen. That's Novartis's argument. What FDA chose to do, rather than answer the question, is it no less safe without it, was to say, as a scientific matter, we can't conclude that it's the safest and best tolerated. And Judge Walker, that leaves me in the end to
No,
your
they go
question.
more than that. They say it doesn't provide a scientific basis for including I'm leaving a few words out here, the Entresto dosing regimen, or not having, puts patients at any greater risk.
It does
Or
not
it's critical
provide a scientific
for
basis to
safe and effective
conclude,
use.
as you assert in your petition, that the
Mhm.
standard Entresto dosing regimen puts such patients at a greater risk.
Right, or is
But that-
critical to ensuring safe and effective use.
And that is a logical lapse to say that because we can't conclude that it puts patients at a greater risk, we can conclude that it puts patients at no greater risk. That gets to your kind of Rumsfeldian known unknown question, right? If we don't know, if FDA approving this drug didn't know in 2015, did this create less risk or not? We're going to put this on because all indications from that page range I showed you show that there are certain folks who benefit from that slower titration regimen. They can stay on there longer.
No, they
So,
might.
Certain,
They might.
they might.
They might not.
They might not, but
Might
that's,
means might not.
but that's the problem for FDA, right? Because in order for FDA to conclude that it's no less safe.
There's no evidence.
And that's FDA's
That
problem.
titration regime, adhering to that titration regime is necessary to ensure equivalent safety.
That is
No evidence of
emphatically
that. And
FDA's
then-
problem and not ours, Judge Millett.
And then the fact that there was separate findings that individuals on that titration study who had a different titration regime did just as well.
Yes, and you heard all that from FDA counsel as well. But what I didn't hear was an answer to your question. What I think you said is, might be is something. and it doesn't get you to the conclusion that it had to make, which is this is no less safe. If we don't know whether this is safer, that doesn't mean that we can conclude it's no less safe. That's the logical problem with what FDA is setting up here.
So might is a word we use in opinions all the time when we don't want to say whether we know something or not.
Right.
And it may be because an opinion is being joined by different members of the panel who don't agree. And so what you say is this argument might succeed if, and that means might succeed means might not succeed, and might or might not means unknown.
I think, Judge Walker, we're reducing the FDA's actual analysis in 2014 down to maybe below its common denominator might. What FDA said, remember at Joint Appendix 315, more patients were able to achieve and maintain the target dose. We believe the key risks can be managed through monitoring and dose titration. A longer titration period, we agree from a safety perspective, patients who are naive should use a lower starting dose. There's no might to any of those at all.
I said might benefit. I
There's a
remember that.
different might benefit, yes, but the ones that I just read to you are,
But should start at a lower dosage doesn't mean should start at your lower dosage. And they do on the MSN labels start at lower dosage.
Let me-
They
let
have
me-
a titration regime.
let me read the entire quote then. Joint Appendix 627, the titration study was relatively small, but supports the proposed dose titration scheme. Patients who are naive to ACE inhibitors, ARBs, or on low doses should use a lower starting dose,
A
not
lower starting dose,
it.
not that lower starting dose.
I think that's.
They do, on the MSN label, they start with, they have a lower starting dose, do they not?
Not for patients who are ARB naive. That is nowhere on the label,
Then
including in
it's
section
just
5.
Generic, that's how you, the starting dose, it's not qualified, is it?
But this is the close enough problem, I think, Judge Millett.
No, it's not. Where does it say titration step doses? Where does it say, but not for those folks?
I don't think it needs to say, but not for those
Okay, so
folks.
for everybody, the starting dose is lower than the second dose, which is lower than the final dose, for everybody. So your thing that they should have a lower starting dose is fully satisfied on this label.
No, I don't think it is, Judge Millett. I think we might be talking about two different things. What the lower starting dose was that was directed, not recommended, but directed in the Entresto label, is that you have the starting dose when you're working with a population that is vulnerable to ACE or ARB drugs. That's the distinction. I don't think it's an answer to say there's a reference to up titration elsewhere in the label. There are no further questions. Thank you, Your Honors.
Thank you very much, counsel. The case is submitted.
Case number 24-5056. John S. Morter, appellant, versus Pete Hegseth, Secretary, Department of Defense. Ms. Floyd, appointed amicus curiae for the appellant. Mr. DeGennaro for the appellate.
Good morning, Your Honors. Erica Hashimoto from the Georgetown Law Center's Appellate Litigation Clinic. With the court's permission, third-year law student Ashley Floyd in our clinic will be presenting the argument on behalf of amicus in support of Mr. Morter. Thank you very much.
Thank you. Ms. Floyd?
May it please the court. When DIA learned that Mr. Morter, a man who has dedicated over 3 decades to serving his country, had been diagnosed with an anxiety disorder, It chose not to accommodate this disability as encouraged by DoD policy, but to reassign him to an entirely different position, hundreds of miles away from his family and his home. First, the district court erred when it held that Mr. Morter failed to exhaust his reasonable accommodation claim. Second, the district court erred when it held that no reasonable jury could find the secretary's proffered justification as pretext for intentional discrimination. This court should reverse both holdings. Mr. Morter exhausted his reasonable accommodation claim because DIA had sufficient notice that he was raising that claim. Not only did he raise the claim in his EEO complaints, but both the AJ and EEOC ruled on the merits of that claim. Here, the procedural posture of the administrative proceedings helps establish this point. First, the AJ ruled on the merits of Mr. Morter's reasonable accommodation claim. It decided that although Mr. Morter was entitled to a reasonable accommodation, he was not necessarily entitled to one of his choosing. The agency implemented this order. On appeal, the EEOC reversed and vacated the judgment in part for two reasons. First, because in addition to raising a reasonable accommodation claim, the EEOC recognized that Mr. Morter's complaint had raised a disparate treatment claim, and the agency needed to conduct factual investigation on that matter. Second, it found that the record was inadequately developed with respect to why Mr. Morter was no longer permitted to work at SOCOM, given that he had been there for years without having successfully completed a polygraph examination.
Ms. Floyd, in the informal discrimination complaint, which I think was in June of 2014, and then again in the formal discrimination complaint, which I think was in July 2014, what's the best sentence that you can point to and say, here it is. Here is Mr. Morter requesting an accommodation?
To directly answer your question with one sentence, I would point the court to JA 232. At the bottom of the page, it begins, in addition, CP, which is Mr. Morter, provided that he believes he is being discriminated against due to a mental disability that essentially invalidates measurements obtained through the repetitive. JA 232, apologies, and JA 233.
Okay, thank you.
Yes.
An accommodation claim.
That's correct, Judge Millett. That Mr. Morter was making clear to the agency that he was requesting to be accommodated per DoD policy for his inability to complete the polygraph examination procedures. And again, just to remind the court that the purpose of the exhaustion doctrine is to give the agency sufficient notice of the claim and the opportunity to investigate that claim and resolve the matter internally. Here, this was more than satisfied because Mr. Morter raised the claim in his complaints, but also because the AJ and EEOC recognized that that claim was there.
And his formal complaint, when he says, J 229, the corrective action he's seeking is either return to work there or another position within the local commuting area. You read that also as a reasonable accommodation request?
That's correct, Your Honor.
So both the informal and formal are requesting relief, not damages or anything like that. It's an adjustment.
Correct. At the time, Mr. Morter was requesting relief to be exempted, postponed, or the a deferment of the polygraph examinations, which again is consistent with DoD policy, which recognizes that polygraph examinations are a supplement to and not a substitute for other investigative procedures.
I think maybe the government says that Mr. Morter was not asking for an accommodation. Instead, he was requesting certain remedies in light of the discrimination that had occurred against him. What do you say to that distinction?
To that distinction, I would just, if I'm understanding your question correctly, it's that the Rehabilitation Act requires the agency to make reasonable accommodations for individuals. And when Mr. Morter was asking to be relieved of the discrimination against him, part of that was to be given a reasonable accommodation by the agency. Moving to the disparate treatment.
If you'd been the victim of discriminatory treatment, would the remedy generally be you get a job somewhere else? I wouldn't think if it's discriminatory treatment, you would get your own job back, whereas he said,
Yes, Your
"Well,
Honor.
give me another job in the area."
Yes, Your Honor. And the record is clear that Mr. Morter could still do his job. He was very good at his job. He was simply unable to take successfully complete polygraph examinations. And moving to the disparate.
So I guess, I don't mean to interrupt you on this, but as we get into disparate treatment, I'm trying to understand the disability here. So it sounds like from what you just said, and I think this is consistent with the record, that I think someone said it was a situational anxiety, that his anxiety, I mean, he was doing just fine until this whole polygraph process started. Is that accurate?
Yes, that's accurate.
He didn't claim to have any sort of disabling anxiety disorder before that. It was a polygraph processing that sort of set this all off. Is that right?
The evidence seems to suggest that, yes, Your Honor.
Okay. So if his disability is sort of a situational anxiety that pertains to having to take polygraph examinations and then all the sort of ensuing hubbub that comes around that and failing, or not failing, that would have inconclusive ones. I get this hasn't been argued, so if it's fine, you can just say it wasn't argued. I'm just curious as to why this is a qualifying disability, because I don't know what major life activity it affects. Is taking a polygraph exam a major life activity?
The major life activity, I believe, would be working, being able to work. And
He can work, he just can't take a polygraph exam. That's the whole point, is he can do his job just fine. He doesn't need any accommodations for doing his job. He just wants an accommodation for not taking a polygraph exam. Normally, you know, the relevant disabilities that affect major life activities mean I have a wheelchair, I need a door with a wider office for my work every day. I'm just curious, and again, it hasn't been raised, so you could just say,
I
it's
do
not
think
raised, and so the government didn't raise it, so they forfeited it. I was just curious as to how this was affecting a major life, why taking a polygraph is a major life activity.
I think my answer would be the government has not raised this argument, and so I do not have
Fair
an answer
enough.
for you. And I see my time has expired. May I continue?
Yes, you wanted to talk about disparate treatment.
Yes, the
I
disparate
interrupted
treatment
you.
argument. A reasonable jury could infer from the totality of the evidence that Mr. Morter was discriminated against on the basis of his disability. I think here a reasonable jury could find particularly compelling the causal nexus. And
When did he first inform the agency of his anxiety disorder?
the formal disclosure of the situational anxiety disorder occurred in November of 2013 when he met with Dr. Sutho. There he was directed to meet with an agency psychologist to determine why he was unable to complete the polygraph examinations.
Right,
There,
he didn't find a qualifying disability. He found that, in fact, ordinary polygraph processes, Dr. Suthu at least didn't diagnose him with situational anxiety disorder.
Dr. Sutho did recognize Dr. McGee's previous anxiety diagnosis, but ultimately determined that the symptoms of Mr. Morter's situational anxiety was, quote, probably easily attenuated by.
Right, so the first time that Mr. Morter informed the agency of a diagnosis, because Dr. Suthu was not signing off on that, was when? Did he submit the McGee diagnosis in October 2013? to the
In,
agency?
in November of 2013, during this meeting with Dr. Sutho, he provided documentation. And again, Dr. Sutho was an agency psychologist, so this
Mhm.
information and previous diagnoses were sent on to other officials at DIA.
Do we know when they were sent on to other officials at DIA?
When they were sent on,
Mhm.
the report was signed as December 4th, I believe. It was early December that Dr. Sutho's report is dated as. And I do believe that because the agency had directed
But did
Mr.
that report that went to the agency say he has an anxiety disorder that's a qualifying disability relevant to taking polygraph exams? Did that Dr. Suther report say that?
No,
Do you recall
Dr.
it saying that?
Dr. Sutho's report did
Okay.
not say it,
So
but
when's the first time the agency was given a diagnosis? I mean, the McGee thing's like a line. It's not much to it. A diagnosis that said he has a qualifying disability of anxiety disorder
Mhm.
that affects his ability to take polygraph exams.
this would be in August of 2014. And this
Right.
was from Dr. Tucio's report. Mr.
Right.
Morter was taken to a 5th polygraph examination in August and was unable to complete that. However, following this examination, he was emotionally distraught, so distraught that DIA required him to immediately go to a psychologist. They
Mhm.
accompanied him to this appointment with Dr. Tucio,
Mhm.
where the doctor observed that Mr. Morter was hyperventilating,
Right.
shaking, tearful, at times on the verge of a panic attack. And it's just 2 weeks after DIA observes these severe physical manifestations of Mr. Morter's now anxiety and PTSD that Mr. Norton reassigns Mr. Morter to a
I know,
different
but they first
position.
proposed that reassignment in February 2014, before they'd been notified of a qualifying disability. That's when they made the initial recommendation to reassign. So when the initial decision to reassign is made before they have any knowledge of a qualifying disability, how could a reasonable jury conclude that the decision to reassign was based on his qualifying disability?
Well, Your Honor, a reasonable jury could interpret the evidence differently and take the disclosure that occurred in November as DIA having knowledge of Mr. Morter's disability. That would make the initial reassignment recommendation by the panel in February to have been made with notice of Mr. Morter's disability.
That requires, so he hadn't submitted anything to the agency, and Dr. Suthu said, not an issue. But we have to find in that notice that was enough to make them engage in contextual decision-making, even back in February 2014, before they had an official diagnosis from him.
Well,
It's a little hard to rely on Dr. Suthu because he just did not make that diagnosis.
that's correct, but Dr. McGee did make that diagnosis. And again, Mr. Morter provided Dr. McGee's diagnosis and documentation to Dr. Sutho in the agency. From this evidence, a reasonable jury could find that DIA knew Mr. Morter had situational anxiety disorder. A reasonable jury could also infer pretext from the fact that Mr. Norton did not actually think Mr. Morter posed a threat to national security. It's clear from the record that at no time did Mr. Morter have his security clearance revoked. And
Well, it was revoked, it was just reinstated.
I don't think so, Your Honor. I think Mr. Morter retained his security clearance at all times. For example, in January of 2014, Karen McCord, the chief of the Central Adjudication Facility, made a favorable SCI determination clearance. And it's our understanding that you cannot have a SCI designation without also having a top secret security clearance. The government is also agreed with us and the district court below that Mr. Morter did not have his security clearance revoked. And this is at JA 346, where the government says it is not in dispute that plaintiff did not have his security clearance revoked.
Not revoked, but maybe not revoked, but they continue to press the issue. They continue to, they're concerned that he can't pass a polygraph, make him take it again and again until he does.
Your Honor,
And when he can't, they say, there's some degree of risk here. We're not going to go all the way to pulling a clearance, but we're not going to impose this risk on a different agency. What's wrong with that?
Your Honor, a reasonable jury could find that DIA was not actually concerned that Mr. Morter was unable to pass the polygraph examinations. Again, although they required him to take more polygraph examinations, they didn't contemplate a reassignment until after the situational anxiety was disclosed, and they didn't actually reassign him until after the anxiety and PTSD diagnoses were disclosed. And I would also point out that there are other employees at DIA, including Mr. Morter's direct supervisor. Again, I mentioned Karen McCord and a senior adjudication officer who reaffirmed Mr. Morter's judgment, reliability, trustworthiness, and this was also in light of the fact that he was unable to pass the polygraph examinations. And it is important to recognize.
So you had the agency he was working at, SOCOM, which is incredibly sensitive information, incredibly important and secretive military information. And that client said, we can't have someone here who's a vulnerability. We have a zero margin of error at SOCOM. We can't have him. And so DIA had no ability to force him on SOCOM. And he's not arguing that SOCOM was discriminated against him because of his disability or disputing that an agency of that level of sensitivity has to have sort of a zero tolerance rule. So he was going to have to be reassigned. That's just sort of undisputed on the record. He could not continue to work at SOCOM. So given that, and given that he doesn't dispute that he could still work at SOCOM when the client agency refused to have him on board, what is the discrimination in reassigning him? Is it the particular reassignment to DC?
Well, Your Honor, DIA, who I agree was the ultimate decision maker here, did have another option, which was to follow its own policy and exempt or postpone Mr. Morter from taking the polygraph examinations until he was emotionally, physically.
Fine, but he couldn't go back to SOCOM in that time period. There just doesn't seem to be any, and if I misunderstood, please let me know. I didn't understand there to be any argument that he had a right when there was this vulnerability, at least this potential risk, to continue his job at SOCOM. And so he was going to have to be reassigned somewhere. Is there any dispute about that?
I think there is a dispute about that. Mr. Morter did not need to be reassigned because
Outside, so he could, his argument is I should have been allowed to continue working at SOCOM.
in the SOCOM facilities in Florida. That's correct.
But SOCOM had said, and DIA says, we can't force an employee, he's a civilian employee, we can't force that on a military unit that will not take somebody. And it's hard to think of anything more sensible than SOCOM not taking on someone who has any risk at all. The costs are way too high to the military and national security. So if he couldn't go back to that job, and if I misunderstood it, is he arguing that SOCOM discriminated against him because of his disability, or DIA?
Our claim is that DIA discriminated against Mr. Morter, and I
Okay.
think the
So
problem.
then what was DIA supposed to do? They couldn't send him to SOCOM, so they had to give him another job. Is that correct?
At the point in time where we are making this decision, that's correct. But I think it's important to back up a little bit and consider the fact that Mr. Morter asked for a reasonable accommodation. A reasonable accommodation that would give no one in DOD reason to believe that Mr. Morter posed a threat or risk, a concern to national security.
Wait, it's a reasonable accommodation to ask people to think a different way about him?
No, Your Honor, the reasonable accommodation was to exempt Mr. Morter from taking the polygraph examinations. Mr. Morter
Okay, but
was
then
not.
he can't do jobs for which polygraph examinations are required.
Again, DOD
He's
recognizes.
definitely a reassignment to a new job.
DoD recognizes that there are individuals who will not be able to take polygraph examinations because they are medically, psychologically, or emotionally unfit. And this is from regulation, from policy DoD instruction 2H.
Mhm.
Mr. Morter was one of those individuals.
Mhm.
Had he not been subject to the consequences of an inability to complete the polygraph examination, there is no evidence in the record to suggest that Mr. Morter posed a risk to national security. And again, this is particularly important
They
to
said he wasn't-
emphasize.
They weren't going to affirmatively find he was a risk, but he was definitely a vulnerability.
I don't think Mr. Morter, a reasonable
Well,
jury
that's
could
what they
find.
found, that he was a vulnerability. A reasonable jury couldn't find that someone who, I couldn't even keep track of how many polygraphs he did, a half dozen or more, and was unable to get a positive result on any of them,
There were,
and had been violating rules by doing research on how to game the polygraph test.
there were a total of 5 polygraph examinations. None of these polygraph examinations measured Mr. Morter's risk. They measured his anxiety. And the researching into polygraph examinations, as the record demonstrates, is a symptom of Mr. Morter's anxiety. He was an overly self-conscious person. And this research, the disclosures, the memos were all out of concern that he was not being truthful to DIA, which he very much wanted to be. A reasonable jury could find, in light of all the evidence, that Mr. Morter was discriminated against on the basis of his
And what
disability.
exactly is the reasonable accommodation he wants? Not to take a polygraph exam, but what about his job? I mean, not taking a polygraph exam doesn't help because he can't work at SOCOM. And so what job accommodation did he want? Stop taking polygraphs and let me work where?
If, to remain in his position, Your
At
Honor,
SOCOM.
at SOCOM, correct. If he
Which-
did not have to
I'm-
take,
Is it a reasonable accommodation to say, I want to continue working as someone who refuses for national security reasons to let me work there? Is that a reasonable accommodation?
it is when the national security justification was pretextual.
You think SOCOM's decision, which is not involved in all of this stuff, was pretextual? I had thought the whole case was about DIA, and it's all these DIA officials. We don't have military generals here from SOCOM explaining their decision-making. This isn't a record about SOCOM's decision-making, it's about DIA's, right, which is placing people in SOCOM and presumably other locations. And they said SOCOM refuses to take him until he can pass a polygraph. And we can't, policy matter, we can't force SOCOM to take somebody who hasn't passed a polygraph. So it just feels to me like his accommodation had to be another job. Right?
If there is a dispute about the reasonableness of an accommodation, that is a question on the merits of the reasonable accommodation claim. And as this court has recognized last year in Ali v. Reagan, the reasonableness of an accommodation is typically a question for a jury to resolve.
Does he have to propose something that would be reasonable? That's available or no?
No, he does not have to make the proposal that's reasonable. The obligation is to provide the accommodation. And again, I think this is a matter for factual dispute that a jury should be given the opportunity to resolve. Thank you.
Can I ask about, do you happen to have the district court opinion, JA 400?
Yes.
That's page 10 of it, which is what my question's about. The second half of that page,
Sorry, which page are you on, 10?
it's page 10 of the opinion,
Mhm.
and I think it's 400 of the JA.
Yes.
Here, an explicit charge of failure to accommodate is absent from Morter's EEO complaint, as is any factual allegation that could be construed as a request for accommodation. I know you disagree with that. We talked about that already a little bit. Further, the notice of partial acceptance, which details the charges that the DIA chose to investigate, shows that the agency understood Morter's complaint to allege solely discrimination on the basis of mental disability, anxiety order arising from 3 incidents, and then it lists the 3 incidents. My question is about the next 2 sentences, and especially the last sentence coming up. There is no evidence in the record that plaintiff ever objected to this narrow characterization of his claims, nor does he allege in his opposition that he did. I wondered if there's anything in his district court opposition that you could point to where he objects to this narrow characterization of his claims.
Mr. Morter does not object to the narrow characterization of these claims, and that's because his reasonable accommodation claim is itself incorporated into these characterizations by the notice of partial acceptance. So the factual allegations that Mr. Morter alleges was summarily the continued reliance on polygraph examinations despite knowing that it conflicted with his disability and the reassignment that occurred from this. This is, and just to remind the court that Mr. Morter was proceeding pro se as he filed these, and his complaints are to be construed liberally. But
I'm not blaming you.
yes, he was not required to object to the characterization because even that characterization includes his claims. If there are no further questions.
Thank you very much. We used up all your time, but we'll give you a couple minutes, Bevel.
Good morning, Your Honors. Assistant U.S. Attorney Stephen DeGennaro on behalf of the government. Your Honors, the heart of this case is that Mr. Morter repeatedly failed the exact same portions of his counterscope intelligence polygraph examination and admitted to conducting research into those polygraph examinations after initially denying conducting that research. This caused leadership within his duty station at Special Operations Command to lose trust in him, and they restricted his access to their classified systems and workstations. In response, DIA realigned Mr. Morter to a position in DIA's headquarters, as DIA had done with other employees who did not have disabilities. When Mr. Morter initiated EO proceedings, he complained that his reassignment was discriminatory because of his disability. He did not include in his formal complaint that he had requested an accommodation from DIA, nor did he indicate that the agency had denied any such request. For those reasons, I will respectfully submit that the decision below should be affirmed. Now, I want to first start
You
with
all have
the...
never disputed that this affects polygraph anxiety disorder, situational anxiety disorder, affects a major life activity. So you accept that he's qualified, otherwise qualified individual with a disability.
Your Honor, we pressed several arguments below about the merits. We're solely up here on the basis of the failure to exhaust portion.
You can
Of
always
course,
argue alternative grounds for affirmance, but did you argue below that it was not a qualifying disability because it didn't, or relevant disability? 'Cause it didn't
Your Honor, we did
affect a
argue.
major life activity?
Your Honor, we did argue that he was not an otherwise qualified individual below. We also did argue below that there was no request for an accommodation that was made here. So there are
But you
additional
didn't raise
grounds.
a major life activity question below.
I do not believe that the government
So that
did,
was
Your Honor.
forfeited. Okay.
I want to first start with 2 points with respect to the request for accommodation. Judge Walker, you had asked for my friend's best sentence within the formal complaint for the EEO counsel report that would support an idea that there was a request for an accommodation. We depart from amicus from Mr. Morter and don't believe that that sentence is sufficient to put the agency on notice that it needs to conduct an investigation into a reasonable accommodation claim. There is no statement that Mr. Morter had requested an accommodation of somebody from DIA. There's no statement that would indicate that he had requested or that he had described what that accommodation is, nor is there any factual statement that suggests.
Why isn't suspend the pending reassignment until the polygraph issue is resolved? Is that not a request for an accommodation?
Judge Millett, that the statement as to remedies, that can also be read as requesting retroactive reinstatement, which is of course a remedy that can be awarded in the
Until the
case.
polygraph issue is resolved. We need to work something out here. That's not an accommodation?
That is not a request for accommodation as we read it. And
How do you read it?
I read that
It's
as
not
a,
saying suspend it forever, never make me do another one again.
again, Your Honor, I read that as a request for a
How?
remedy.
Well, that's what a reasonable accommodation is. It's a remedy. You have to show that you're qualified for your disability. And what I want is this accommodation. And then when it's denied, people argue that that was, if they think it was improperly denied, then it's a form of discrimination known as, failure to provide a reasonable accommodation. But your argument was he didn't ask for a reasonable accommodation. And I'm pointing you to number 2 and telling me how a temporary suspension until an issue is resolved is anything other than a request for an accommodation.
Your Honor, our position is that that is a remedy that is equally applicable to disparate treatment
Equally
claims.
to both means it raises both. You have to show that, which my eyes can't read it that way. You would have to show this is for a pro se, clearly requesting only relief for disparate treatment and not an accommodation while we work out how to deal with this disability.
Your Honor, counsel for, or amicus counsel for Mr. Morter had pointed to, or referenced the case Ellie versus Regan. That individual, the employee in that case was also pro se. One was able to sufficiently put the
That's
agency
not
on
our
notice.
test. We don't say, well, if one pro se somewhere was able to do something, we will read everything that every other pro se does in the strictest light possible. This is a temporary request here. This is not permanent. This is suspend something until a polygraph issue is resolved. That's not permanent relief, which is what you get for disparate treatment. That's work with me.
Yes, I understand, Your
That's the
Honor.
essence of a reasonable accommodation. I don't understand how you could read it as anything otherwise.
Well, Your Honor, again, the request for an accommodation needs to be made. And the test from this district
Okay,
is that.
we have it. And I'm not making this up. The administrative judge read it as just a reasonable accommodation claim, addressed the reasonable accommodation claim. It went up to the EEOC and they didn't say there's no reasonable accommodation claim here. They said, yeah, there is, but you know what? There's also a disparate treatment claim. So go back and also address disparate treatment. Now, if you take that sentence, you take what the administrative judge did, what the EEOC did and said, and sent them back to do. Tell me how you put all that together to say nobody was on notice that he was asking for a reasonable accommodation.
Well, again, Your Honor, I think the fact that the details in the formal complaint, aside from the remedy language that you point to, in the EEOC counsel report, focus solely on the fact that Mr. Morter is saying that he's being subjected to differential treatment because of his disability. With respect to the administrative judge
I'm sorry, I don't
appointed,
understand that again. What are you saying?
that when you look at the EEOC counsel report that Mr. Morter
Yes, that's
attached to
what
his
I'm
formal
reading
complaint.
from.
Yes, but what is absent from that EEOC counsel report are any indications that witnesses were asked, what do you know about the request that Mr. Morter has made? Who responded to that request for an accommodation? Why was it denied? Those are factual details that
Sorry,
would be
so who was
present.
supposed to ask those things?
The EEOC counsel report would be investigating that claim had they believed that Mr. Morter's formal complaint had put the agency on sufficient notice of the existence of that claim. And again, while there's not,
Maybe that's a failure on his part, but that doesn't mean it's a failure on Mr. Morter's part. I mean, there's a problem with the EEOC counselor's work. That doesn't mean that he didn't do it because the administrative judge and the EEOC, again, the administrative judge thought it was just reasonable accommodation. You give me any case, even with a represented party, but certainly with a pro se, where it's raised there in words to me that sound entirely accommodative, and the administrative judge does a whole decision on reasonable accommodation. And it goes up to the EEOC and they say, okay, they don't say, what are you talking about, reasonable accommodation? They say, yeah, but you forgot disparate treatment.
well, Your Honor, first point as to the administrative
Any
judge,
case that has said that's insufficient for a pro se.
I do not believe that there's been any decision that has weighed in one way or the other,
Have
whether
you
that
got any
suffices.
case where the agency, two levels of agency addressed a reasonable accommodation claim, and yet a court has held that a pro se did not raise a reasonable accommodation claim? And there is language right there in their formal, informal complaint that seeks accommodation.
Your Honor, I am not aware of any decision that
We'd be
addresses
making new
one way
law
or the
for
other.
pro ses here. You can't find any case where we've read a pro se application with this level of stringency and closed our eyes to how the experts on the ground, the administrative judge and the EEOC viewed it.
Your Honor, I don't believe a new test needs to be rendered in this case. I think
Okay,
that,
first time, I'm not aware of any case either, where the language is right there. It's not remedial damages for disparate treatment. It's not completely put me back where I am. It's put me in a different, either suspend this thing or in its formal complaint, give me a job somewhere in the local commuting area. Right? Those are accommodations and nothing else.
yeah,
And it's fully addressed by the agency process at 2 levels, 2 times.
well, two things. First, Your Honor, while acknowledging the fact that the court has the discretion to consider arguments that are raised for the first time on appeal, our position is that the arguments about the administrative judge and the EEOC decision are forfeited because Mr. Morter did not press that below.
Wait,
To the
wait, wait,
extent-
wait. Did he argue below that he had exhausted his claim?
He argued below that he had raised that claim
That he
in
had
documents like the
exhausted his
notice of
complaint.
appeal.
Right, and we have pretty clear precedent that says a new argument in support of a claim that was preserved below is not a waiver issue. It's entirely permissible. Appellate lawyers do it all the time, come up with new and better arguments for claims raised below. He argued, it's in his complaint, and he argued to the district court, I made this claim and it was exhausted. He was a pro se, he didn't know that he was supposed to cite a couple pages in the record to point the district court to. But it was in his complaint, he made the argument. So he's not making a new argument here, he's pointing to additional pages in the record.
Well, then our
Does the
second,
government want to live by that standard for its arguments on appeal?
Your Honor, I would not want to get ahead of the Solicitor General on that point.
No, the government, I'm sure the government does not. And so we aren't going to apply a different standard. You wouldn't ask us to apply a different standard of forfeiture to a pro se than we would to the United States government, would you?
Again, so
Do you apply the same one, at least the same one?
I think Your Honor is articulating a point about the fairness of
Should
allowing.
we apply, no, I'm asking you about the legal standard. Should we apply at least the same legal standard for preservation of issues, but advancing some new arguments in support of them on appeal to pro ses that we do to the United States government and other represented parties?
Again, Your Honor, I would not want to get ahead of the Solicitor General.
What, you can't answer that question?
Your Honor, I acknowledge that pro se litigants shouldn't be held to a more stringent standard than represent parties to include the United States government.
So our case
But our
is that say you
additional,
can make new arguments in support of claims raised below. He gets the benefit of that too.
yes, Your Honor, but that ties in with our second point about whether this had been properly teed up for investigation. Is the report of investigation, which we included at the beginning of our supplemental appendix, shows that the focus of that investigation that followed from this formal complaint was solely of one of differential treatment and not of a reasonable accommodation. I read the
document
OFA.
he created?
Sorry, Your Honor?
Is that a document he created?
No, Your Honor, it's the report of investigation that the agency had created when it followed. It took the allegations that he put them sufficiently on notice about in his formal complaint, as many other federal sector employees who engage in the EEO process do without representative counsel. And they understood that claim to be one of disparate treatment and not one of reasonable accommodation.
Is a failure to provide a reasonable accommodation as a matter of law a form of disparate treatment?
Your Honor, I believe we cited cases in our brief that discuss, from other courts of appeals that discuss that those are different types of disability discrimination, that differential
but-
treatment
They're
and
both forms of disability discrimination. They're both forms of differential treatment. Because the whole point is I'm otherwise qualified, and yet you're treating me differently than other people who are also qualified for the job but don't have a disability.
well, Your Honor, I would.
Not accommodating me with this reasonable accommodation. It's just like religious discrimination under Title VII, right? That it's still considered disparate treatment when you fail to make an accommodation that you reasonably can make.
Well, Your Honor, I would gently push back on the idea that those are coextensive claims. In the case of a disparate treatment claim, there is discussion about whether the impermissible factor is being taken into account in the personnel action. In the context of a reasonable accommodation claim, the fact that the employee has a disability is being considered, and the merits of
Yeah,
those
it's taken
claims.
into account, and the question is whether we can accommodate it. They both take them into account. The question is whether we tried an accommodation or not.
Well, the key factual dispute and disparate treatment claim is whether that impermissible factor was considered in the employment action versus in the accommodation. You're litigating whether the reasonableness of the accommodation that was being made to account for that
It's
disability.
not what it was considered. It's whether in disparate treatment is whether it was sort of the causal reason for the adverse action that resulted. It's considered. And both of them, you can't not. So it's just a question of causal connection for disparate treatment or failure to accommodate. I don't see what the point is, what the difference is. To say that they looked at it this way, I mean, they were aware, you all gave them a reasonable accommodation. From your perspective, by reassigning, you didn't fire them. You reassigned them to DC. You said, this is the accommodation that we can do to address your vulnerability. Right? That was your accommodation. You didn't fire them. You didn't say we don't want you working here with your disability. You said the best way to deal with your vulnerability, the vulnerability that results from your inability to take polygraphs, is we got to reassign you to someplace where that's not a vulnerability or can be mitigated by other means, correct?
Your Honor,
You offered him an accommodation.
I don't know that I would characterize the evidence as saying it was providing him an accommodation. I think what the evidence shows in this case, and you touched on this with your question on the disparate treatment claim with the other side, is that it's not in dispute that SOCOM no longer wanted him in their facility, and DIA, as his employer, had to determine how they were going to respond to that. And the way they mitigated the risk associated with that persistent failure of the polygraph examination is that they said, we're going to bring you back to headquarters where we
Keeping
can.
you on board, and we're going to give you a job that lets you keep working with your disability, but addresses the vulnerability concern.
Again, I think, Your Honor, that is something that does not reflect that the agency
not
was
an
thinking of as a
accommodation?
response to an accommodation. No, because again,
Wow,
that we don't believe
okay.
that this was a
Wow.
request for an
Giving someone
accommodation.
a different job that they can do consistent with their disability, the government doesn't believe that's the type of accommodation.
No, Your Honor, we're saying that on this record, in this case, we don't believe that the evidence supports the.
So on the record, in this case, giving someone a job, didn't fire them, that is consistent with their disability, allows them to continue to work consistent with their disability. In this case, it wasn't an accommodation. But if you did it for someone else, it might be an accommodation. Is that what you just said? You said on this record?
No, so on this record, Your Honor, I believe that the
Why is it
evidence
not an
shows.
accommodation on this record?
Because again, I don't believe, Your Honor, that the evidence supports the inference that there was a request to be accommodated made of anybody within DIA. And
Maybe it was a really good agency that was proactive, didn't want to discriminate based on disability, wanted to keep this long-term employee on board with all his skills and experience if they could, but they had to find a position that was consistent with the anxiety disorder that prevented him from taking polygraphs, or at least taking them in a way that could operate successfully to evaluate the risk that he posed. And so the agency said, I think you would be trumpeting this. The agency said, this is the best we can do. Disability, I would have thought y'all would say we did exactly what we're supposed to do here.
again, Your Honor, I think.
Your position?
I think our position is that this case fits within Park versus Howard University and in the cases that
Your
were
position
cited.
isn't that the agency did exactly what the law expects it to do in this context.
That is your position. That has to be, you're saying we did everything right. That's what you're saying.
Yes, Judge Walker, of course, our position is that there's no discrimination here. It's more of, I just wanted to push back on the notion that the way that the agency chose to mitigate the risk associated with the polygraph examination, I don't believe that that fits within accommodation as that word is used in the Rehabilitation Act. This is merely a decision by a national security apparatus to help mitigate a potential
We had
vulnerability.
affirmatively asked, can you assign me somewhere? This polygraph. Thank you for giving me 5 different tries here and lots of time and space between them. It's not working. Can you reassign me somewhere where the risk issue is mitigated so that I can keep working? I've been here a long time. Obviously want to retire and I've got a lot of skills and benefits. Can you reassign me somewhere? Would you understand that as a request for an accommodation?
If Mr. Morter had indeed asked
If he had
somebody-
asked for that, would you consider it a request for accommodation? Yes.
Yes, Your Honor.
Can something be an accommodation if it's the agency's idea, even if the party didn't ask for it?
Something may be an accommodation, a reasonable
All the
accommodation.
time.
Yes.
All the time. Okay.
Can I ask, assume that we think that Mr. Morter did exhaust his accommodation claim. I'm not saying we do or we don't. Could we then reach the merits of the accommodation claim and say it's not meritorious?
Yes, Your Honor. This court has the discretion to affirm on any basis that's found in the record, and Judge Millett suggested the qualified activity as one. We'd also press below that there was no indication that he had actually requested an accommodation to be excused from these polygraph examinations. And finally, the fact that there's evidence in the record to support that Mr. Morter was required to pass these polygraph examinations. SOCOM no longer wanted him in their facility. The only reasonable accommodation that could be offered was this reassignment to DIA headquarters where they can more effectively mitigate the risk associated with his polygraph examination. So yes, Your Honor, there are additional grounds to support affirmance on the accommodation claim if you were to decide that it had been in fact exhausted.
Is there any evidence from you that there wasn't anything in the area? I just don't know DIA's structure down in Florida. So the SOCOM's out. But there wasn't, did he ask for, identify, or was the agency aware of anything that, I think his concern is he needed to stay in Florida. It's gonna be too hard to move.
Yes, Your
Is that
Honor.
an open record question, or is it just, there's sort of what DIA does down there is so common, nothing else? I have no idea.
So in addition to, so the place where Mr. Moore worked is an Air Force base where there's SOCOM spaces and US CENTCOM spaces. And one of the things that Mr. Norton did right before affirming the decision to reassign him was to check with CENTCOM, see if whether they would be willing to monitor Mr. Morter to make sure that he didn't present a security vulnerability. That would not necessitate that he move out of the Tampa area. And when they checked, CENTCOM said that they didn't want to bear that risk. So
I'm sorry, who asked that? He did, or someone in the agency asked?
someone within DIA had requested.
So they checked for an accommodation. Okay. And so so those are the only sort of 2 options down there, and both of them are obvious. I mean, obviously incredibly sensitive operations. So this isn't going to work for us. Is that what you're telling me?
That's correct, Your
Is
Honor.
that
That's
in
what
the
the
records?
evidence.
Where is it in the record?
The CENTCOM, there's reference to it on page, I believe it's JA 333. Yes, it's at JA 333 where it's summarizing the steps that, so it starts, it's 2-page email starting on 332 and going on to page 333
Which
where
document is that? I'm trying to figure out.
this is an email that Mr. Morter had received in response to a FOIA
The
request.
Final reassignment email, is that it? Or?
Yes.
Okay,
yes, Your
got
Honor.
it.
Again, in there, that's where there's the discussion that they had received his notice to appeal.
Mhm.
They conducted the 5th polygraph examination where, again, in that instance, he successfully completed the sabotage, espionage, and terrorism portions, and it got hung up on the classified info and the foreign contacts part for a 5th time. They conducted an interview to see if the interview was able to work through the issues that Mr. Morter had with the polygraph. And then they also asked whether somebody in CENTCOM would be able to host him for a position there, and the answer was no.
Okay.
I see that I've gone well over my time,
That's
Your
all-
Honors.
That's my fault, I think.
No, so for the reasons that we've stated here and for in our brief, we'd respectfully request that this court affirm the judgment below.
All right, Ms. Floyd, we will give you 2 minutes for rebuttal.
I have 2 points on rebuttal, Your Honor, one with regard to the reasonable accommodation claim and one with the disparate treatment claim. As to the reasonableness of the accommodation, this court has held, and I'm quoting here from Ali v. Reagan, that deciding the reasonableness of a given accommodation not uncommonly involves context-based decisions ill-suited for summary judgment. Here, it is in dispute whether Mr. Morter's accommodation that was provided was a reasonable one. Again, the agency DOD instruction allows for the postponement and exemption of polygraph examination procedures, and that is what Mr. Morter asked for.
Well, so not uncommonly is not the same as never, and this was a summary judgment decision. So did he come forward at summary judgment with evidence that would create disputed question, material fact about the existence of an available alternative position for him in Florida, a DIA, same DIA location in Florida?
He did not come forward with a different location, but
Or different job? Did I identify something that he could do consistent with their need to address the vulnerability that he posed?
the accommodation, again, this is likely not the answer that you're looking for, but the accommodation was to be deferred or exempted from the polygraph examination procedures, which would allow
And
him
keep working
to,
in these sensitive places.
exactly. And I do
He
recognize
didn't have
that,
another one. He wasn't aware of some other job there that he could, because.
That's correct.
I'm forgetting now, was his formal, informal complaint says, or assign me to somewhere else in the metro area.
no, he does not ask for that. And my second point is that it, as you mentioned, these are incredibly sensitive positions. And DIA knew this, and this was the case for the 2 years that Mr. Morter remained in his position, despite still being unable to complete the polygraph examinations procedures. During that time, DOD followed his policy, which is that polygraph examinations are a supplement to, not a substitute for, other investigative procedures. It was not until the disclosure of his diagnosis that DIA decided reassignment was necessary. I have no further points. If you have any questions, Your Honors.
Okay, Ms. Floyd and Ms. Hashimoto, you were appointed by this court to represent Mr. Morter in this appeal, and the court is very grateful for your assistance. Case is submitted.
Is a facility to be used for export. Second, if these are two distinct facilities, the commission improperly concluded that the connector pipeline was not a Section 7 pipeline. And third, FERC violated NEPA because it improperly limited its alternatives analysis and its indirect effects analyses. Before I dive in, I'd like to provide a little bit of context. This project is a 157-mile, 48-inch pipeline designed solely for transporting all of the gas that it will carry. It will start at the Waha hub with no interconnections in Texas before it reaches the international border, where it will connect to a proposed pipeline in Mexico and ultimately transport gas to a proposed liquefied natural gas on the West Coast there. This is one single pipeline within the United States, yet the Commission is only claiming jurisdiction over the 1,000 feet at the border. We think this is a legal error. I'd like to first start with FERC Section 3 jurisdiction. The question here is whether or not the Natural Gas Act prohibits FERC from exercising its jurisdiction beyond roughly that 1,000 feet at the border. Nothing in the Natural Gas Act, FERC's own implementing regulations of the Natural Gas Act, or the Department of Energy's delegation to FERC authorizes the approach that's taken here.
This all stems from the need for a Section 3 license to export.
Yes, Your Honor.
You don't think export has some connotation of what happens at the border?
I believe that
Or FERC couldn't view it that way?
I believe that in the language used in the Natural Gas Act and in FERC's regulation and in DOE's delegation, they're dividing the word facility that comes with the term export. So Section 3 of the Natural Gas Act, pretty limited language, and just says no person shall export any natural gas from the US. But FERC's regulations require Section 3 authorization for those applying to site, construct, or operate, quote, facilities which are to be used for export. But the delegation order from the Department of Energy gives FERC authority over three different things: the ability to approve or disapprove of the construction and operation of particular facilities, the site at which those facilities will be located, and when new facilities for export are to be constructed, the place of exit for export. So those are two specific things: the place of exit and
The
the
site and the place of export. To me, that has some connotation of the point at or near the border. And there's obviously gray area about, is it 1,000 feet? Is it, the high water mark of the Rio Grande or the low water mark? But we're talking about at or near the border, not what happens 100 miles upstream.
Yes.
They couldn't view it that way?
Well, Your Honor, FERC has long interpreted this Department of Energy delegation as giving FERC jurisdiction over the siting and the operation of the facilities necessary to accomplish an export. And just that 1,000 feet is not the only part of the facility that's necessary for export. The gas cannot get from the Waha hub to the border without the entirety of the pipeline. This pipeline's 157 miles long, but FERC is viewing it just as this 1,000-foot project, despite nothing in the record showing any rationale for that limitation aside from we've done it in the past. And this is
Why, speaking of that though, I think FERC started doing this in 1989, almost without exception. They've got the zigzag case across the Canadian border, but putting that aside, for 30 years until Big Bend comes along. And even in Big Bend, it wasn't raised until it was too late. Why did it take 30 years to discover this very significant legal error?
Your Honor, I believe that the determination here is a fact-specific one. There are certain projects where if you look at, I think, Valley Crossing in South Texas, where there are other uses for the gas that's being transported there. That was another instance where there was a pipeline crossing the international border in South Texas, but it had other uses. It wasn't transporting all of the gas contained for export. There were other interconnects along the way, and that could be the case for other projects that have applied this same standard.
Do you agree? I think intervener said that your position in this case would upset years of precedent and billions of dollars of investment.
Your Honor, I believe that it would give a clear criteria for what counts as the facilities necessary for export. And for certain projects, if there's no other use aside from exporting everything within it, I believe that it is all an export facility. but for projects where they are branching off with interconnects to supply gas to, say, a small West Texas town or other uses for it along the route, that would be another fact-specific decision there. And here, all the gas is for export. Yes, Your Honor.
And I'm not good at geography, but if you have this same pipeline, but it's double its length or whatever it takes, so it actually starts in Oklahoma. And it goes Oklahoma across the border into Texas, but just directly to this export facility. So all it does is take gas from Oklahoma to this export facility. And I take it your position is the entire pipeline from Oklahoma to this export facility should be treated as the Section 3 facility. Is that correct?
Your Honor, yes, in that instance, if there's no other, they're going to build a pipeline that long for those uses because Section 3 is for the export of gas, but that's under the assumption that there are no other interconnects or uses along.
That was my hypothetical. That's all it is.
Yes.
And so your position would be the same, no matter how long this pipeline is. If it's from Canada, crosses the border there, comes all the way down the United States to this facility here, you're going to call assuming this is not, that's all it's doing is straight in and out. You want that whole thing be subject to Section 3.
Your Honor, I believe that would be similar.
I'm sorry,
yeah.
Section 3, that's the Section 3 review or jurisdiction by FERC, correct?
Your Honor, I believe that could be a combination of Section 7. Because
No, why? You said that it's an export facility. All it's doing, it's an export facility. And if I don't understand why it's any different. And take out Canada. So say it starts in Minnesota. I don't know where there's gas, but Minnesota, whatever, comes all the way down. And all it does, one pipeline all the way down to Mexico. You said this for Oklahoma across Texas, it's just all export facility.
Yes, Your Honor.
I'm just making it longer. Does it change at some point?
I do not believe so, Your Honor.
Okay, so then you can't say,
Yeah,
then you can't
apologies.
throw Section 7 in here right now.
Yes.
That just seems like a really bad idea because you know how Section 3 reviews are. There's a presumption that they get approved, absent showing of adverse public interest. I mean, it is a strong presumption. It is much less, much more pro the pipeline or this export facility, much less demanding scrutiny and paperwork and showings than you have under Section 7. Correct?
Correct.
Something's in, my two hypotheticals are definitely interstate.
No.
But those things would not be subject to Section 7 regulation at all because they would all, under your theory, they would all be treated as the export facility. That's your position?
No, Your Honor, I believe
You
that,
just told me that was your position under my two hypotheticals.
I believe I misspoke and got a little turned around. I believe that in a hypothetical like that, at a certain point, a line would be drawn on what is necessary for export. But here,
Wait, how would you do it under my hypothetical? Say, I've got my gas here. I make so much more money if I export it to Mexico. It's all going straight there. What's the line? I don't understand what your line is. I know your line, you want it to be more than was it 1,000 or 1,400 feet here?
Your
But
Honor-
what is your test? What is the test that we, FERC, whoever, are supposed to apply to decide when it stops being the export facility and starts being an interstate pipeline or something else? What is your test?
Your Honor, I believe the test would be something similar to what was applied in Alaska Gas Line. I know that was an LNG case, but the term facility there was defined as gas that was destined for, or that was transported for export and was not subject to Section 7 jurisdiction. And it would be a similar
Well,
test.
then you should have given a different answer to me about Oklahoma and Minnesota.
I believe I misspoke, Your Honor. I apologize.
So now essentially what you want is a rule that says if it's coming from an intra-state pipeline, and we have issues about that, but assume it qualifies as an intra-state pipeline, and all they're doing is taking Texas gas from wherever in Texas straight down to the border. Then it's the whole pipeline.
Yes, Your Honor.
But if it crosses a state line, but it's doing the exact same thing, it's just an inch into Oklahoma, it's no longer an export facility.
Yes, Your Honor.
And the rationale for that, I mean, I know you say that's what you want, but I'm still understanding what in the statutory text precedent or anything would allow this type, requires FERC to draw the line that you want rather than the one they drew.
Your Honor, I believe that would be very similar to the pipelines that attach to, say, liquefied natural gas terminals and supply gas to those as well, where some part of the project is Section 7 and some part is Section 3. But the facilities that are just for the export, so that have no other purposes, that are not going, those would be Section 3.
But you just said that's not the test you want. I mean, that was the first answer, that if they're just for export, but you're saying if it crosses a state line, but it's still just for export, that's not the test. This is why I'm really confused,
Yeah.
because I should think that Sierra Club would, I don't mean to speak for your client, would prefer Section 7 regulation to Section 3.
Yes, Your Honor, I believe that,
And so how far out you want to draw the, I mean, and we don't just go, well, I like that more than that. There needs to be some, for us at least, some sort of legal basis for saying that FERC had to define the export facility longer than it did in this case. And your answer is, well, let's look at LNG, and we say if it's just for export there through the LNG terminal, that's good enough. But then you don't like that answer here. So I still don't know what your test is.
Your Honor, I may be talking back some of what I
Mhm.
previously said. I got a little turned around. But I believe that the test would be the facility is necessary, and then when it crosses state lines, it is interstate.
So your test is just interstate things. If it's interstate, the whole darn thing is. And if it's interstate, how much is?
Pardon?
If it's interstate, how much is the export facility, and how much is subject to, is this, is a Section 7 facility?
Yes. The facilities that are like the language
See, Section
used.
7, you're going to have to include some of this, the pipeline in Texas so that you're crossing state lines.
Yes,
So
Your Honor.
how far in? What's the test?
Usually there's additional infrastructure in those locations where you could draw a line, such as compressor stations or meter stations or something like that. In this instance,
I don't
there's
understand. They're all exclusively for export. I don't understand why that makes a difference. If you just want a rule that says if it's just an intrastate pipeline, then the whole darn thing has to be part of the export facility. But if it's an interstate one, it happens to be, let's imagine the interstate one here is it's in Texas, but it's right at the border. But if you add another foot, so it's in Oklahoma, then we have a whole different test for the export facility. I think that's what you're telling me.
yes, Your Honor.
And I don't understand the legal basis for that.
Here, it's the fact that nothing in the Natural Gas Act nor in FERC's regulations specific to the Natural Gas Act give them authority to divide it into two separate projects. We're just talking about the portion at the border. And I know that there are instances where they could fully
You're the one that
extend.
wants to divide it into Section 7 and Section 3 if it crosses a state line.
Yes, Your Honor.
Why can't, I'm sorry, do you have,
No, no.
Go ahead.
why can't FERC take seriously third possibility, which is state regulation? This thing won't be unregulated. There's a Railroad Commission of Texas, which on FERC's view will handle this. And the interstate, Section 7 part of this takes that seriously, and crossing a state line is very significant. And if it crosses a state line, it's interstate and FERC controls it. But if it's just within Texas, the state gets to control it. And that's the scheme. Why can't they sort of just think of it the same way in the export context? What's crossing the border is FERC's business, and what's inside the inside the state of Texas is the Railroad Commission's business.
Your Honor, I believe that it's just a coherent standard of review for a single project. So how FERC looks at the environmental harms of a project, how FERC notifies landowners, how FERC assesses environmental harms is different than what the Railroad Commission does. So breaking a project into two gives two different forms of environmental review, public notice, and the like. But here, FERC has failed to coherently.
I mean, it breaks projects according to orders. And that's, maybe not a modern way of thinking about it, but this is a pre-1937 scheme. That's the way things were set up then.
Well, one of the issues here, Your Honor, is that FERC has failed to coherently explain the legal framework that it's applying here. It offered one explanation in the authorization order of the Saguaro project and now offers a differing explanation before this court in briefing. And both of which, like we've discussed earlier, there's past actions where FERC has extended its Section 3 jurisdiction. So FERC's authorization order originally takes the position that FERC could never assert jurisdiction beyond that 1,000 feet at the border, and now says that this jurisdictional approach is something they're able to do under the terms and conditions they're able to set. But as we discussed earlier, FERC has extended its jurisdiction for export pipelines, such as in San Diego Gas and Electric, and as in those Section 3 LNG cases. And the question is whether or not FERC needs to engage in a fact-specific determination on whether or not an individual border crossing pipeline is more like those LNG cases where it's attached or San Diego, but nothing in the record provides a coherent standard for FERC's position. And FERC's decision here rests on this error, and we believe it's appropriate to remand for FERC to decide whether to exercise authority that they denied that they had. So,
You're pretty sharply distinguishing between this threshold question of authority and whether FERC should exercise it or not. I mean, can't we just sort of look at what they've done over 30 years, as Judge Walker says? They have a nod to federalism concerns. I mean, it's pretty clear whether you call it a lack of authority or a declination, deciding not to exercise authority. That's what they've been doing. That's what they're going to do.
Your Honor, we just believe that FERC needs to explain the rationale it's using and why it's deciding to separate this project into differing projects. Moving on
Your
to,
position is if this had been from Oklahoma, it would have been perfectly appropriate, maybe even required for FERC to have severed off the export facility and then treated 155 miles under Section 7. In my hypothetical, it's interstate. Is that right?
yes, Your Honor.
Okay. So you don't have any problem with it dividing the thing up?
Not whenever the same agency is viewing the project as a whole. They can look,
Completely, it's very, very different regulatory regimes under Section 3 and Section 7. So your whole argument, I think, is just, you can't, it's perfectly rational to make the division that was made here, as long as we also get Section 7 jurisdiction. But if instead we're left with intrastate pipeline Texas jurisdiction, it's no longer rational and they need to have more explanation.
yes, Your Honor. I know I'm over time, but is it all right if I move to?
Did you want to have another point you wanted to address?
I was going to address Section 7 and NEPA, but if you would like me to save my time.
Just give me 30 seconds. On Section 7, give me 30 seconds why this is controlled by Big Bend. Intrastate goes up about 100 miles. The company says the upstream connection will be to an intrastate pipeline. They have in-state sources. Maybe there's some question about getting 311 authorizations in the future, and we said that's fine.
Your Honor.
Intrastate, not Section 7.
Yes. Your Honor, in Big Bend, one of the factors was the fact that that pipeline ended near the Waha Hub versus at the Waha Hub, which is a source of interstate gas. They also mentioned the fact that there was abundant gas that they could supply into the Trans-Pecos pipeline, which is the pipeline in Big Bend. Here, they've identified the one pipeline they're going to connect to for sure is the West Tex pipeline, which we have identified gets interstate gas. And we raised that in our rehearing order and in comments that the West Tex system, which the West Tex pipeline connects to, gets gas from other states as well. And we believe that the commingling of gas makes this pipeline interstate. And I will.
Just any more questions? Were there any answers you were not able to give to our questions today that you would have been able to give if we were in sealed session, closed session?
No, Your Honor.
Okay, thank you.
Thank you.
Good morning, Your Honors. May it please the court, Jared Fish for the Federal Energy Regulatory Commission. I'd like to start by making a few points on Section 3, move to Section 7, and answer any other questions about any other topics the panel has. The Commission reasonably found that it has jurisdiction only over the border facility at the United States-Mexico border. That determination is rooted in the statutory text. It's rooted in the Commission's regulations, in the Department of Energy's delegation order, and as you noted, Judge Walker, at least 30 years of precedent. First,
How did you decide how, oh, please go ahead.
Is that something we would assess for reasonableness post Loper Bright? It seems like there's a legal question. You either have jurisdiction or you don't.
Correct. I think it is a legal question that this court should decide in the first instance. De novo, yes, yes. So beginning with the statutory text, as you—
I actually want to get to something more specific, and that is, how did you define how much was the export facility here? It doesn't seem to be a consistent amount in cases. It seems to vary a fair amount.
Sometimes it varies a bit. We're talking about a few dozen feet here or there, 1,047 feet or 1,000 feet or 950 feet, with two exceptions, the intercity case from Minnesota and the San Diego gas case.
So how do you decide how much it is? It looks to me like you just took what Saguaro said. You just took their number.
Well,
Same thing in Big Bend.
we need to draw an administrative line somewhere, Judge Millett.
You need to draw a reasoned line as to how much is the export facility. And so if you can tell me what test it is that FERC uses to define how much of it is export facility. I mean, I get the thing that's connecting to Mexico, but
Right.
you got to have some test for that. And I didn't see it in the decision. If I missed it, please tell me. I haven't seen any of the decisions. It seems to me that FERC just takes whatever the applicant is proposing as a definition, but I'm sure that wouldn't be what FERC is doing. I'm sure you've got a better answer than that.
Well, I have two responses, Judge Millett. First, as concerns this case, all Sierra Club is arguing, the only issue in dispute is whether we were required to assert jurisdiction over the entire 157-mile pipeline. They don't quibble with how we drew 1,000 feet, whether it should have been 1,500 feet or 950 feet. They want all or
I'd be a lot
nothing.
happier if it had been 80 miles, split the difference.
Well, that's not what they argue. They argue it had to be the whole
I'm
thing.
just asking you
And
how you all make the decision. Or does FERC make an independent reasoned decision? Does it have some test it applies to define how much is the export facility?
The test that we use, and this is not directly responsible, but the test that we used is our precedent going back for 30 years. And I think it's
And what
important.
is that test? Please tell me what that test is.
The test is something close to the border. I mean, when we're talking about Section 3, it can't be zero because there's some distance that a facility takes up at the border. But the statute, our regulations, the DOE's delegation order doesn't give us any principled basis or criteria to use to determine what that length is. So we've had to draw what is admittedly an administrative line, which generally, when we don't have any criteria to go on from a governing statute or regulation, we get great deference in drawing
You
that
have to make a
administrative
reasoned
line.
decision. And by the way, they did quibble with where the line was drawn. It's in their brief. But, so tell me, you get discretion and you may have expertise in this area. So what's the test?
The test is our precedent, and
That's not telling me
sometimes
that our precedent is not a test. Precedent may apply a test. Okay, and so is it, and maybe there's something structural here, I don't know. Is there a building that's the export facility? Is there a particular change in the piping? Or do you just sort of, does this 1,000 foot just sort of in the middle of a pipe somewhere say, this, now we're export facility and the rest of it is intrastate?
right, I understand the frustration, Judge Millett, and I did inquire as to whether there is anything in the record that might elucidate whether there is a physical piece of equipment at 1,000 feet that could constitute a marker. Perhaps Council for Saguaro, which is building the project, might have a more specific answer. But
So
we've,
it's
I
just sort
think,
of an undifferentiated pipeline that at some point, presumably it's sort of right on the border, connects with a Mexican pipeline?
correct.
I had a vision of like a building, okay?
Yeah.
Not even a building. So you're just
Well, and oftentimes,
randomly dividing up the,
I
you're
don't think-
randomly dividing up the pipeline.
I don't think it's random, Judge Millett. I would say, 1,000 feet is about 0.2 miles. And 0.2 miles is, a rough approximation of what a facility might occupy, say, an LNG terminal or liquefaction
Did
facility.
Is there
FERC say
any-
that I'm sorry, did FERC say that somewhere?
No,
The
FERC
0.2?
did
No,
not say
you're
that.
saying that.
I'm saying that,
Okay.
but this is, I think it's also important to recognize here, this hasn't, our line drawing here hasn't been challenged in 30
It
years.
isn't.
We're going,
It's a challenge in this case.
it's, yes.
Is there, in the LNG context, there's a whole facility and you can point to it and it's near the border. Is there anything here like that? Do you need a meter station maybe or anything associated with crossing the border? Or is it, as Judge Millett said, is it just that the pipe just continues from the US under the river, over the border, and it's one pipe and it eventually is in Mexico?
Here it's one pipe and eventually it's in Mexico. But, when we're talking about onshore facilities that actually have to liquefy natural gas to prepare it for send off and export by vessel, there is a very clearly demarcated physical,
So the
infrastructure.
1,000
But
foot, it's not roughly the edge of the river, it's just a nice round number, nice round and small number.
and to that point, Judge Katsas, I think it would be more.
1093 wasn't all that round in Big Bend. Curious why that was 93 feet longer.
That's true, Your Honor. I think in this case where
What's
we
the-
are just drawing
What's the longest you've done for one of these?
I
You said
think
it's the
the,
export facility.
I think the intercity Minnesota case, but that's really the
How long was it
exception.
there? Remind me how long it was.
It was several miles. By the time you looked at weaving in and out of Minnesota, it was several miles. I think it was 2.1 miles in San Diego. But I think those are the exceptions that really prove the point
I
that when
don't
Congress.
understand what point you're proving. So some places, I mean, the in and out one is a little potentially different, but 2 miles in San Diego, 1,093 in Big Bend, 1,000 here. Is the only difference what the petitioner asked for? Applicant asked for? Not the petitioner, the applicant.
I can only say that it's consistent with what the petitioner asked for here. And I think it would be arbitrary for us to choose, say, 1,012 feet or 1,050 feet in a case where we have to draw an administrative line without criteria governing it.
I thought you said a few minutes ago that you draw a line that's close to the border. Now, close is not the most precise test imaginable, but I mean, it is as close as a standard of sorts. 1,000 feet, close. 500 miles, not close.
Right, Your Honor. And I think, when we're looking
2
at,
miles close?
it's certainly much farther
What about
away
San Diego.
in San Diego, but, there,
I mean,
There,
there,
it- we-
difference.
Well,
If you imagine that at 1,000 feet, we're doing that because at 2,000 feet, there's wetlands or there's homes that are going to have to get bulldozed. Going to be a lot more consequences to recognizing that as within our jurisdiction. That would be problematic, wouldn't it? If sometimes it's 2 miles, but if it's going to cause too many regulatory issues, we'll make it 1,000 feet. I mean, it seems very troubling that FERC doesn't apparently have any test for how much is the export facility.
well, Your
And
Honor.
that's where all the gravamen of your argument is, export facility, section 3, rest we're going to sever off. But we're supposed to accept that argument without any understanding of how you all define what the export facility is in any reasoned and consistent manner.
Well, I would push back that we've been inconsistent. I think the fact that there are two exceptions, only two
You call them
exceptions,
exceptions, I don't know.
well, only two instances,
Why were
when we
they-
have 30
why were
years.
they exceptions?
Uh,
The reason that it was 2 miles, did they explain why that was longer there?
Well, in San Diego, the whole length of that pipeline was 2 miles. So you can see that FERC might be more willing to extend its jurisdiction over the full 2-mile length of that pipeline rather than a 155-mile pipeline. In Minnesota, the concern was that there would be no state
I don't
jurisdiction.
understand that rationale. Oh, if it's short and not going to cause any difficulties, we'll do the whole thing. But if it's going to cause problems, we'll make it so short it doesn't cause problems.
Or we're going to act consistent with what we've decided before. I think it's important to remember here, Section 3 doesn't require us to assert jurisdiction over border facilities at all. All Section 3A says is we get to approve, well, DOE now gets to approve exports, and FERC and DOE may apply reasonable terms and conditions. And this court in 1974 in District Gas said, it took a pretty broad view of what terms and conditions means. And it said, okay, terms and conditions is broad enough to encompass facilities that are used for export. But that case itself involved an onshore LNG terminal, a self-contained facility.
Can I ask you about LNG? Do I have it right? In the context of LNG, exporting LNG, would FERC take the position that a 100-mile pipeline wholly within a state leading to an LNG terminal is part of the export facility?
Yes, and we have in Alaska Gasline, and there's a very good reason
So
for that.
why- Is there a difference in
Yeah.
pipelines that lead into an LNG terminal? and
There's a
other
difference in the
pipelines?
statute, and this is the critical point. LNG terminals are governed by Section 3E
No,
of the Natural Gas Act.
Right, which says the pipeline, it's excluded if it's subject to Section 7 jurisdiction.
It says that, but it also says that our authority over LNG terminals covers all natural gas facilities located onshore or in state waters that are used to transport natural gas. That's where we get our authority to regulate pipelines that are part of an LNG terminal that could be up to 800 miles long, as in Alaska Gasline. The point here is
For 30
Congress.
years, facilities used
So-
for export. I'm sorry, go ahead.
No, so, I mean, whether through that provision or by negative implication of the pipeline exclusion, at least if the mechanism of export is LNG, it seems like the 100-mile long intrastate pipeline is part of the export facility.
Because Congress expressly said so in Section 3E, and the court, of course, presumes that where Congress includes language in one provision but omits it in another, that relative
Critical
inclusion
distinct language for you is,
is the fact that Section 3A, which we all agree we're under here, only says that we get to apply terms and conditions to exports, whereas Congress was explicit in Section 3E that we may assert jurisdiction over pipelines that deliver gas to LNG terminals.
terms and conditions.
Well-
You have, your position is that a term and condition includes some portion of the pipeline. That's what your position in this case. For 30 years, you have read that language to say it includes some portion of the pipeline used for transportation of gas for export.
Some portion, but.
Some portion, okay, so
but
you have the authority to cover some portion. Is there anything in the statutory language that says that has to be a different length of pipeline than we use for LNG?
Yes, because in Section 717, which is Section 1 of the Natural Gas Act, Congress spoke specifically to our jurisdiction over pipelines. And Congress said, we regulate only interstate pipelines, and we regulate no other pipelines. We don't regulate pipelines located wholly within one state. And so if we were to interpret Section 3,
Unless it's transporting LNG.
unless it's transporting LNG,
Okay,
but we're
but
not
that's-
in that provision.
I understand you're not, but I'm trying to understand how you read the language in 3A to let you regulate up 2 miles of pipeline, but no more. You definitely get to regulate the pipeline carrying the gas for export under 3A, correct? For some length.
For some length,
Okay, okay.
because this court in district gas said so. Yeah,
Were we making it up or were we interpreting the statute?
you're interpreting the
Thank you.
statute.
All right, so you get to regulate the pipeline delivering gas for export, some length of it. And there's nothing in 3A, comparing the language to 3E, that says it has to be close to the border.
Well, I think, Your Honor, the court.
Or 2 miles is okay, but 5 miles is not.
I think it's.
That's why I was asking you what FERC's test is.
Right, I understand. If I could come at this from a different angle, the courts read the statutes as a whole. Congress spoke specifically to our regulation of pipelines in section 717, and it said, we don't get to regulate intrastate pipelines. So if we were to interpret section 3A, which uses a vague, ambiguous term like terms and conditions, to completely eviscerate that line in section 717 that says we don't get to regulate.
You wouldn't be completely eviscerating it. You would be applying it to only those pipelines that are used for export within the state. That's not evisceration there any more than it is for LNG pipelines. And it doesn't eviscerate it to do it for 2 miles. Would it eviscerate it to do it for 5 miles?
But Judge Millett, what is the
Would it
limiting principle?
Eviscerate it to do, your position is it doesn't eviscerate that protection to regulate them for 2 miles. That's the commission's position.
Well,
Yes?
That's what we decided in San Diego.
Is that your position?
That's not my position in this case. That hasn't been our position in virtually every case. I don't know
Are you
that the issue.
disavowing? Oh, has the commission sort of confessed error and said that was wrong to do 2 miles there?
I'm not confessing error,
Oh,
Judge
so
Millett,
that's still
but
your precedent. And I'm just telling, on what basis? You can't say that 3A says we can't regulate pipelines at all. If FERC had said, read that to say, oh, we can't do anything, maybe the connection pipeline to Mexico or whatever joint or something goes in there to connect the two, maybe that we can regulate because that's the actual export point. But your whole point, you said there's some big textual distinction here, and yet that textual distinction does not exclude regulation of a portion of an intrastate pipeline.
it does. That's correct, because
Okay.
when it comes to looking at what terms and conditions are attendant to exports, the action of allowing exports.
But the whole
the-
thing is for export. That's why it doesn't make, I wish FERC had a test, and then we could say they have expertise or something, but if the entire thing is one pipeline, and there's no meters, there's no facilities, there's no buildings, all you've got is a connection to Mexico, I guess at some point, Mexican pipeline at some point, then there seems to be, and I see nothing in the statutory text that is answering this question that says 2 miles is okay, or even 1,000 feet is okay, but 3 miles isn't, 4 miles isn't. That would be totally blowing up this interstate pipeline exception. You're
Right.
regulating intrastate pipeline in this very case, just not the whole thing.
Right, because this court has drawn a balance between our authority over exports under section 3A and well, yes, in intercity, we did. We said that was a unique, we used the word unique.
Canada one. was-
Yeah, unique,
Yes.
and
So I'm
also,
putting that aside. That's why
but-
I'm talking about the
but-
San Diego one.
but we also said that there would be no state jurisdiction there. And in San Diego, I think that case actually supports our ultimate determination here that we can't regulate, I know this isn't precisely your question, but we can't regulate the entire connector pipeline or even several miles because we disclaimed jurisdiction over the to-be-constructed intrastate pipeline to which that 2.1-mile spurt segment interconnected. So I think, the fact that we said in one case,
Right,
okay,
there's an
2 miles.
interconnection there. That's a break point. You don't have that here.
Not that I'm aware of, that there's a breakpoint. The
How many
breakpoint,
times have you done it at about 1,000?
many times, dating back to Michigan Consolidated Gas in 1989, where we said we only get to regulate facilities that are close to the border, perhaps before then. But in Valley Crossing case,
So the reason given there was it 1,000 feet there?
I don't know that we specified, no, I'm not sure if it was
This-
exactly
This is
1,000
a weird
feet.
thing, right? Because it's always a different length. If you were just like either a physical facility, right? If you have a new interconnection or building or a meter or something, and otherwise we'll do 1,000 feet, that would be consistency.
I understand, and
2,000 here.
and
As I look at them, and I could be, you have access to a lot more than I do. It wasn't the same number all the time. That's the thing that struck me as quite odd.
it wasn't the same number all the time. That's correct. And here we chose a round number. I see that I'm out of time. I'm happy to address.
On the section 7 issue, so do you guys have more on this? On the section 7 issue, it seems to me that there's very unclear that they've got, this is unlike Big Bend, because there's no finding that there's sufficient intrastate Texas gas.
I
to fill the
disagree.
capacity of this. They talk about, here's 8 other facilities. They don't say that those have available capacity. Normally what FERC says is there's evidence that those have available capacity. Maybe you got a contract, but if you don't have that, there's evidence those have available capacity. Was there any evidence that there was available capacity to fill or come close to filling this pipeline?
Yes, Saguaro's representations that it was proposing to build a header system that would, this is JA 398, that would aggregate the gas from those 8 upstream sources. And those 8 upstream sources could supply 5 billion cubic feet of gas.
Those 8 may well have the capacity to provide that amount of gas. Is there any evidence to think that gas is not already contracted to other pipelines?
That's
Don't they have
not,
to show that that's available for us to pick up, to get?
well, what they have to
If there's
show.
gas that's not being shipped that we will pick up?
I don't know of any case or FERC precedent that requires that showing. What is required is a showing.
Turned out that all 8 of them were already contracted to other facilities. Would this be a reasoned decision by FERC? There's sufficient capacity available?
If there, well, first of all, the test with respect for Section 7, determining whether the pipeline is Section 7 jurisdictional or not, is whether it's only going to transport non-NGA jurisdictional gas, not how much of that gas it's actually going to transport. And also, we're on the substantial.
Is that how your 4-part test reads?
Whether there are.
What's the third prong of your 4-part test?
Whether there are ample sources of intrastate gas.
Ample sources. Is ample sources more than 20%, 7% of a very wide diameter pipeline?
Well, I'd say, first of all, there's no, minimum volume that needs to be satisfied upon commencing surface service for an intrastate pipeline. That's never been the inquiry. And second,
Hey, you have to show that you've got an incredibly wide diameter pipeline here. It says it's going to take only intrastate gas down to the border. That's what it's designed to do. And yet there's no evidence in the record that there's available gas, and this is on a particular route, this pipeline, that there is available Texas gas to fill 50% of this pipeline, 60, 70%. Is that correct?
I don't think that's right, Your Honor. First, we're on the.
Why is just identifying a source of gas without showing that it's available for them? That that's shippers there that need this pipeline or need some pipeline to ship with. You said if those 8 are at full capacity or fully contracted out already, would that be a reasoned decision? Would that
If,
satisfy the third prong?
if there were no capacity or no volume available to serve the pipeline, and there was evidence of that, then perhaps. But again, we're on a substantial evidence standard. The question is whether
Yeah,
there's more than a
substantial evidence means that there
scintilla.
is some available capacity for this pipeline to use that is intrastate. And 27% is sufficient? That isn't how I read the third prong of your test, because the third prong of your test is let's make sure that this is really going to be transporting intrastate gas, which means you've got to show that more than a quarter of this pipeline is going to be filled with intrastate gas.
Well, first of all, Saguaro has made representations that they are going to transport intrastate gas, and they can make that
They make
representation.
representations.
Well,
What's the evidence? A representation is not evidence.
we've treated those representations as evidence, and they're binding. They're binding on Saguaro. First, Saguaro is an affiliate of Westex. They have the same parent company. They can determine
Westex
what.
is the source of the 27%. It's these other 8 companies that they're not affiliated with. They apparently have they haven't claimed they have contracts with.
Well, there's something I could say in the sealed portion
Okay.
that would inform that a bit. But if Saguaro were not actually going to transport intrastate gas upon commencement of service, we would know that. There are ways for us to enforce that representation. Pipelines that carry Section 311 gas need to file Form 549D with the Commission. Those forms identify the receipt and delivery points of all gas, including interstate transported gas, on those Section 311 pipelines. So if Saguaro, upon commencing service, isn't transporting any gas,
No, they'll do 27% intrastate. And then the rest, full capacity or 80 or 90% capacity is going to be interstate. What happens then?
well, no, if it was interstate, then we would probably bring an enforcement action, because that would be breaking its representation. But
I
even
said it's
if,
going to have, let's assume they got their 27%.
right,
And then it's easier for me to say 73%, but if you don't want to say 100% capacity, whatever, ratchet it down a bit. But if the rest of it turns out to be interstate, what happens?
well, if it eventually turns out to be interstate, after Saguaro has already secured Section 311 authorization to carry, and I want to be
Well, you're
careful.
telling me the form here to get 311 authorization. If it turns out that initially, all right, so for the first day, they trickle out their 27%. The first week, they trickle out their 27% and they go, yeah, we're losing massive amounts of money here. And so from here on out, so initially, they did their 27%.
Mhm.
But then they don't have any more intrastate gas, because it turns out that's already obligated somewhere else, shipping somewhere else. So then after that, they do 73% or whatever lower percentage you want. Everything else they do after that is interstate. And that's the record they present you and say, hey, we'd love a little 311 authorization here. What happens?
So I have a couple responses to that. First, as far as the statute is concerned, Judge Millett, that's not a problem. There is no requirement that an intrastate pipeline, upon commencing service, fill its pipeline or have no intention of transporting NGA jurisdictional gas in the future. That is just fine. The only requirement is that the pipeline establish itself as an intrastate pipeline, i.e. transport only non-jurisdictional gas. It doesn't matter if it's 10% of the capacity, 50% or 100%. The only requirement is that it's not FERC jurisdictional, and to determine that, the only question the court has to answer is whether all of that gas is non-NGA jurisdictional itself upon commencing service. But there's nothing in our precedent, in the statute, or this court's cases that require a
And then you
pipeline.
just give a 311 certificate after that.
And, I'm not going to presume what the commission would do, but that is consistent with
This is a very
Congress's.
different argument that we got in Big Bend from FERC, which was that they monitor this. If it turns out to be a ruse, that in fact this thing is really an interstate one, it's just got a little tickle of interstate, that there can be a show cause order, that they could then regulate it under Section 7, they could go back, they could impose NEPA requirements. This is a very different argument than we got from FERC in the Big Bend case, which wasn't like, as long as they do it for a week, that's all fine. And they are out of Section 7 altogether, even though after the first week of operation, everything they're doing is interstate gas.
Well, Your Honor, that would be something that we would look at upon Saguaro's if they were to
You
application
just
for
said it's
section
fine. The
311.
statute says it's fine.
There's not, right, there's nothing in the statute there's nothing in the statute that says a pipeline is not an intrastate pipeline that avoids our jurisdiction if at some point in the future, a week, a month, whatever, it actually intends to transport interstate gas. It's a different question on whether we would approve a Section 311 application if it turns out that we discover that Saguaro was just building this pipeline as a ruse to transport interstate gas. That's a separate inquiry, and that could be debated, and that could be litigated. But I think it's important to zoom out. The court can decide the Section 7 issue on one basis, and it's a basis that Sierra Club doesn't dispute. And that's our interpretation of Section 601 of the Natural Gas Policy Act. And this is why it doesn't matter if any of the gas that is transported on the connector pipeline is interstate or intrastate, so long as it's all 311 gas, which we know that it is, because there are no connections to interstate pipelines on the connector pipeline. That is Section 601 A2B, which provides that a pipeline that is otherwise a natural gas pipeline, and only natural gas pipelines are subject to Section 7, is not such a pipeline by reason of or with respect to the transportation of Section 311 gas. And here, the only...
Have they already been given a 311 certificate?
No, Saguaro hasn't, but the only reason why Saguaro could be a natural gas pipeline is by reason of the upstream 311 transportation of interstate gas.
That's the concern we just had, because that same thing could be a ruse. Could show that all along this was intended. And I'm not maligning any particular company here. I'm just raising generic hypothetical points here, but the same things we did in the Big Bend argument, and that is that if it turns out they actually don't have enough intrastate gas to justify this pipeline, especially at this diameter, and never had it. They haven't shown you unused capacity is waiting to be shipped. No showing of that. And a week after, a day after, an hour after the pipeline opens up initially, they shift to all interstate gas. Your argument that this is all fine.
No.
Now, that they don't challenge this, that it's non-jurisdictional because it's Section 311, it's not much comfort.
Well, respectfully, Your Honor, I think we're talking past each other because there are two, not all interstate source gas is Section 7 jurisdictional gas. So the point that I'm making is Saguaro would not even need Section 311 authorization to ship any of the interstate source gas that is upstream from the connector pipeline, because all of that gas is covered by Section 311. And Section 601 A2B of the Natural Gas Policy Act says if you would
Have they shown
be.
that they have that, there's capacity for them to do for that? If that's what their intent to do is?
Well, yeah, that's the only gas available. It's the connections to West Tex and the other eight potential sources of
I
gas.
thought the other 8 potential sources of gas were Texas gas. You're telling me it's not Texas gas, it's 311 gas?
Well, again, I could add a little more information in the sealed portion to that question. But certainly.
So I'm sorry, we don't know on the public record what the source of those 8 reference companies' gas is.
We know that they provide intrastate, that they provide intrastate
You know what
transportation.
percentage of their gas is interstate?
So they're intrastate pipelines. I don't know what percent is interstate or intrastate, but my bottom line point is it doesn't matter. This would be a very different case, if the connector pipeline itself connected to a Section 7 jurisdictional interstate pipeline. Then it would matter for jurisdictional purposes whether the connector pipeline was receiving any of that NGA jurisdictional gas upon commencing service. Because if it was, then no way could it be considered an interstate pipeline. It would have to be a Section 7 jurisdictional pipeline. But here, and in cases where there are interconnections with Section 7 pipelines, Permian Highway, Valley Crossing, where we have found that is not sufficient to take it out of the zone of intrastate pipelines, because there still has to be some showing that the pipeline's going to take gas from those interstate pipelines. Here, we don't even have that. It's undisputed that every interconnection is with an intrastate pipeline. And so because a natural gas, Saguaro is not a natural gas company, because the only reason because the only reason it would be is by reason of Section 311 transported gas, then it's necessarily an intrastate pipeline upon commencing service.
You can finish the sentence.
That's
Would it be accurate to say in this case, as we said in Big Bend, this is not a case where the only realistic or even primary use of interstate pipeline is to provide Section 311 service?
yes.
Okay,
That is.
What's your best support for saying yes?
There's the 777 million cubic feet per day capacity of West Tex, and there's 5 billion cubic feet per day that's available from the other 8 sources. And we know that all of that, if any of that
It
gas.
is available to this pipeline, or it just has gas that somebody's shipping.
Well, I think, I hate to come back to the substantial evidence standard, but I think it is
Well, there's
significant.
substantial evidence that it is available for this pipeline.
The fact that Saguaro is preparing
They said it
is
was.
building a header system to aggregate that gas. Yeah, I think that is evidence that Saguaro is. I mean, if they're misrepresenting that and they actually have no plans to build, then that's certainly something that we would take into consideration if Saguaro ever sought 311 authorization. I mean, or we might bring an enforcement action. But I think respectfully what Your Honor are potentially asking for here is more than the evidence that was required in Big Bend. And under the substantial evidence standard, I think we have more than shown that there's
The
substantial.
evidence in Big Bend was that there was sufficient intrastate gas. Full
And-
stop.
And I would
Not
say,
311, intrastate.
I don't think there was actually an inquiry there whether any of that intrastate gas was already contracted for or not contracted for. I
It
mean,
was already in operation by the time we had argued. They gave us the volumes of how much intrastate gas, 70–80%, had been transporting.
Yeah.
So that's a lot more substantial evidence than we have here.
it might be more in that sense, but I don't think that's
No,
just positive.
This is not the same substantial evidence record as Big Bend.
I
All right.
think Your Honor.
Thank you. You're from Saguaro. I hope I'm saying it right, Saguaro? Saguaro? Oh, I'm sorry, Counsel, did you want to go into closed session, or do you feel like you said enough? Do you feel like you need to go into closed session?
I think it would be helpful for.
All right.
Good morning, Your Honor. Jeremy Marwell. Good afternoon, Your Honor. Jeremy Marwell for interveners, including Saguaro Connector
Saguaro.
Pipeline, Saguaro, like a
Sorry.
W. I would like to touch on both the Section 7 and Section 3 issues. If it's not too jarring, maybe start with Section 3. Talk about the test, the statute, and some of the practicalities that the court was asking about. At paragraph 23 of the rehearing order at JA 415, the commission did say that it has consistently said that when a company constructs a pipeline to import or export volumes of natural gas, quote, only a small segment of the pipeline close to the border is deemed to be the import or export facility for which Section 3 authorization is necessary. So that may not be mathematical, but I think it is a test. The argument that petitioners have advanced in this court, and I think the thing that you need to address, and perhaps the only thing you need to address, is whether that also extends to 155 miles upstream intrastate. And I think that is clearly wrong as a matter of text, context, structure, and history. Happy to talk about the details of the statute, but I think the difference between 3A and 3E, the fact that 3E talks about the words facilities and transportation, 3A is only import-export. The whole structure of the Natural Gas Act is predicated on preserving state role over intrastate pipelines. And I would say, Judge Millett, with regard to your question, what if there was something at 1,400 feet or some sensitive resource. I mean, the petitioners did not make that argument in this court that there was something. I think the court's interpretation in district gas, which really inferred from the reference to import and export in 3A, the authority over facilities, and we're taking district gas as we find it. I think that understands that there has to be some discretion in the commission to draw these lines with respect to the facilities. And of course, district gas was an import terminal, so there was a fence line, and that was the fight. Everybody
A lot
understood.
easier then.
It was. But of course, Congress also acted in 2005 to add Section 3E to the Natural Gas Act to clarify the commission's authority. And I think the key point is just, I think it would be inconsistent with the structure of the Gas Act to infer, to sort of extend district gas 155 miles upstream. And so I think
Is it that they lack the power, or that the commission may have the power under the words of 3A to decide how far up it should go? And thus far, it has done this kind of hard to get my fingers on, but something under the concept of close enough for government work or something.
so. I think
Good work.
post Loper, we think the court should say what the best reading of this statute is, and we think the best reading in the specific context of these border crossing pipelines, putting aside LNG, is that the commission's authority is limited to a short segment of pipeline at the border, the segment that effectuates the international export. And I think that's
The segment
consistent.
that effectuates, so that's going to be like a foot.
Well, maybe I can give
right?
some.
Isn't that
I'm
what would
sorry.
effectuate the export? Would be where you connect to Mexico? Until then,
So,
it's
I
not
mean,
effectuated.
I guess I would concede that the language in district gas and in paragraph 23, the hearing order is not mathematical, 1,000 feet and not 1,001. There are many of these projects, including the one in Big Bend and cited in the commission's brief. Sometimes there is a meter station close to the border. Sometimes there is some other physical thing. I don't think the record in this case shows that that's 1,000 feet. I mean, the applicants try to propose something that is consistent with the commission's precedent in the hope that the commission will apply its precedent consistently. One other observation, our upstream pipeline here is regulated by the state of Texas as an intrastate pipeline. It's actually a gas utility, which is a term of art. You could see that in the record. I think it's a JA 180. And that means we have an obligation to serve all comers, right? It's sort of step above common carrier. And so if folks come along the pipeline and ask for service, that may happen. So I think that just underscores Texas's
Do you have
role.
affirmative representation that Texas will regulate this? Because petitioners have said that it won't be regulated because Texas will treat it as an export facility. And so is there something affirmative in the record that says Texas will regulate the 155-mile?
Yes, the permits we have gotten from Texas confirming that this is. So if you look at JA 189 and at JA 190, that is permit to operate a pipeline in Texas from the Texas Railroad Commission. If I understood petitioner's arguments, Judge Millett, it was more that they disagree with the way that Texas regulates the
Right, which is
pipeline.
a totally different question.
Yes, which I think is a different question. And of course, what you say about Section 3 here is going to apply in Texas and everywhere else we have a border, both at the Canadian and Mexican border. So I don't think it should wax or wane with the degree of stringency that a particular state chooses to operate. I mean, that is sort of implicit in Congress having chosen to reserve authority to the states. On San Diego, I don't think there was any evidence in the commission's decision that the 2.1 was litigated. So I take the point that, we want consistency, but sort of a drive-by jurisdictional ruling, if you don't mind the mixing of metaphors there. And petitioners did not raise San Diego in their rehearing request at all. So I think if there's a sort of failure of explanation concern, I don't think they preserve that on rehearing. So if there are no other
We have
questions.
to decide something de novo. Just trying to ask if they have an informative argument is not something I think someone else can waive from us.
I
Trying to figure
understand.
out.
I think the language that the commission used in the rehearing order that I quoted to you is probably capacious enough to encompass that. And if there are specific cases on specific facts where, somebody comes and says, look, there's a really sensitive resource at 1,500 feet or whatever. I mean, the commission can grapple with that.
Before you move on to section 7,
Yes.
is that where you were going to go?
I was, yes.
Can you expand on the statement in your brief that Sierra Club's position would upset billions of dollars of investment?
Yes. So, I mean, if you look at a map of Texas, there are border crossing facilities all along scattered along the southern border. And all of them are served, we're talking about border crossing pipelines, not LNG terminals, and all of them are served by upstream pipelines. I think what Sierra Club is trying to do here is upset the regulatory status of those upstream pipelines, investment decisions, customers who are being served by those upstream pipelines, the role of the state of Texas in regulating all of those pipelines. And there's a reason this case looks like Big Bend. We can talk about how similar or not. But, you know, investment is made in reliance on the standards and the approach that the commission gives. And this is a system that relies on private parties to invest and build pipelines. So the 30-year stability of that regime, I think, is something the court could consider, even post-Loper. I mean, the concept of reliance and consistency in an agency position, I think, weighs in its favor, even if you don't think, as we do, that you can do it just based on the text. As to whether this is the upstream is an interstate pipeline, won't surprise you. We think this is very similar to Big Bend. Maybe one important distinction to start, Judge Millett, with your question about the 27%, and is it really a ruse? Are we really going to be flowing Section 311 gas? Everything coming onto this pipeline, if we build it the way we told FERC we're going to, which is our intention, all 8 of those sources that are in the sealed map at JA 174 are intrastate pipelines. If we were to, in the future, interconnect directly to an interstate pipeline, which I think what we had in Big Bend, then we would need Section 311 authority. But even as petitioners concede, we haven't said we're going to do that. What we want to build is the thing we told FERC, the thing that's shown on that map. Anything coming off those intrastate pipelines is not a basis to trigger Section 7. So in a way, it doesn't matter how much comes off West Tex versus one of the other pipes that sources directly from Texas.
Well, what evidence is there? Because again, we had the evidence, you know, we had the evidence in Big Bend. Very strong evidence that they were doing intrastate gas. And here it's very strange. I haven't seen cases like this where they go, well, here's 8, whether it's company suppliers or other pipelines, having to call, we'll just say 8 suppliers here that we can hook up, that we could hook up with without any evidence that in fact they have capacity to offer. Any evidence that they have capacity to offer that would be remotely sufficient given the size of this. I mean, you have a great big pipeline here. You must have thought you're going to be doing a large volume of something. So where is there substantial evidence that there's available capacity intrastate to run this pipeline, to make
Right.
it, you know,
So-
economically viable?
I'm sorry.
Sorry,
Didn't
no,
mean
I'm
to-
just-
I get it. So I would tick through the things the court said in Big Bend. First, the entire upstream is going to be physically in Texas. Second, we told the commission we were going to flow molecules produced in Texas. Third, the commission interrogated that, asked us about it. The same evidence, by the way.
Can I ask you something?
Yes.
Just you
Please.
use molecules and that
Yeah.
gives me flashbacks to chemistry and stuff that I didn't understand. So, did you tell them that you will be transporting gas produced in Texas? Is
Yes.
that what Texas source gas means?
Yes.
As opposed to interstate gas that's sitting in an intrastate pipeline in Texas, which is what FERC was suggesting it might be.
Yes,
Because you just said molecules in Texas, and I'm like,
Yes,
okay,
and I-
that sounds
and I-
like it's coming out of the ground in Texas.
it is. And I want to try to be clear about that. We made that representation to the commission. That is our intent. In support of that representation, we gave them the sealed map, which has the names and capacity figures of the 8 intrastate facilities. Some of those flow 311 gas, as FERC is well aware, because any pipeline that wants to flow 311 gas has to ask FERC, and they issue an order. So West Tex. Others of those do not have 311 capacity. We gave an example of that in our brief. It's sealed, but you have it. And that means every molecule is coming from the state of Texas. And so what we told them, number one, this is the first round,
Mhm.
everything's coming from Texas. That's, I think,
Mhm.
exactly the representation that you had in Big Bend.
Mhm.
Um,
Is it
The sep-
available to you all? Where's the evidence of that? What,
So-
you could point to,
I-
and it turns out they already have contracts with some other pipeline.
I understand. So remember, we're a pipeline, we provide transportation service, right? It is up to our customer, who is also an intervener here and on the brief, the principal customer,
Mhm.
to source the gas, the physical molecules, and to arrange the capacity to get it to our facility, right? We just provide it from
Mhm.
the facilities that you see on that map down to the border. That's our job. And I guess right up to the border. So what you have in the record is support from our customer who is intending to take the gas down to Mexico, liquefy it and send it abroad, that this is a facility they're going to use. And we gave them 8 different options. Remember, capacity on pipelines also can come and go. I mean, you might think of it in the context of a pipe going to a local distribution company domestically, where they know we're always going to have, a certain degree of need. But here we are in the same region of Texas that we were in Big Bend, near the Waha region, the hub, the pricing hub. It is proximate to one of the most prolific production regions in Texas. The commission knows that. They are the expert pipeline agency. And when we tell them the names of those pipelines and the physical capacities of those pipelines, they understand that it is a way to interrogate our submission to them.
Available capacity?
Yes,
That's-
and I think if you.
It's just weird that no one ever used that adjective.
I-
It's quite striking.
I understand. I mean, this may not be comforting to you, but one way to think about it is, I mean, if we can't flow the pipeline at 100%, that's a commercial risk the company's willing to take. We're going to invest this because we have a customer who wants to pay us to use it. If it turned out to be a bust, obviously that risk is on us. But the key representation, and I hesitate to draw the analogy, but I think it is important to remember that what FERC does in the Section 7 context, when you're reviewing FERC's action for an interstate pipeline, and I know you've had many of these cases, is looking at, the precedent agreements and is it 50%, is it 75%? That is not the regulation that FERC does under Section 3, because Congress, as you said at the beginning of the argument, created a statutory presumption in favor of export. So it is a lighter-handed regulation. And maybe your instinct is that if this were a Section 7 case, you would demand more proof, of available capacity or whatever. But I mean, here we have the information we gave FERC plus the submissions from our customer in the record saying that, yes, this is something we want and we're going to use. And I think under the substantial evidence standard, at least as the court articulated in Big Bend, that easily passes the test.
Any other questions?
You had been ticking through some similarities with Big Bend. Did you end up getting to all those similarities?
Sorry, I
No, an
Road
answer.
by molecule.
Thank you. So I think I said it, but one similarity is that we submitted information about connections with intrastate pipelines. Judge Millett, in Big Bend, footnote 25 of FERC's rehearing order, so that was the Trans-Pecos rehearing order, talked about information that the applicant had submitted there. It is reproduced at JA 253 to 264 of this court's joint appendix in Big Bend, which is available to you. And you'll see that it is a list of intrastate pipeline connections and physical information about those connections. That's not something that the court specifically referenced in its opinion, but I think it is an important similarity. I think that was all. Thank you.
Thank you, sorry.
Nope, all good.
All right, thank you. We're going to give you a rebuttal, but it may make sense. You didn't have to do one thing closed session. Do you have more, or you said sufficient? Because you pointed us to stuff, we have the materials.
I would be happy to, if the court has questions about the sealed chart at JA 174, which is the chart I've been referring to repeatedly, including the numbers and the specific details, I'd be happy to talk about them. But I think the key point is it's very similar to what you had in Big Bend. All of them are intrastate. And the fact that some of them are 311 is not legally relevant. It's not a ground to assert Section 7 jurisdiction. That's the Commission's Westar precedent, which I think goes very carefully through the
The
text.
answer is no, you don't need to say any more.
I'm sorry. Only if the court had questions about
Okay.
JA 174.
All right, so Does the government still wish to go into sealed
I
session?
agree with that. If the court has questions, but based on Mr. Marlowe's presentation, I don't have anything that's,
Do you have anything you want to ask in sealed session? Do you have anything you want to ask in sealed session? Cancel that. You may come up and have 2 minutes of rebuttal.
I'd like to start with the Section 3 argument. They admit that they have Section 3A jurisdiction. The only question in this case is how far up the pipeline that jurisdiction goes. This is based on the premise that the connector pipeline is a separate project, but nothing divides the facility. As I mentioned, there are no interconnects. And as FERC and interveners have said, as FERC identifies, the end of that 1,000 feet is just a point along the pipeline, and that's at JA016. And interveners state that this limitation is due to the Natural Gas Act and not any, quote, factual or operational distinctions. I'd also like to point to 18 CFR 153.5, which is FERC's regulations for the Natural Gas Act and who should apply for Section 3. A points to any person proposing to site, construct, or operate facilities which are to be used for export. The word border does not come in until Section B, which is any person applying under paragraph A of this section to construct facilities at the border. And that's for the presidential authorization, which is a separate and distinct thing that projects built at the border need to do. This drawing of the line at 1,000 feet has no basis. As we pointed out in our rehearing request, why is this 1,000 feet? Why is it not a mile, 10 miles? What is the distinction there? And it's just inconsistent with their own authority extending jurisdiction on the other pipelines as we discussed. I'd also like to point out that the DOE delegation order is not limited to the border as we previously discussed. It's for domestic facilities, the construction and operation, siting, and for the border location. And they are just misstating it as if number 1 and 2 don't apply to export facilities, and means and, not or. It's supposed to be all of these things. I see that I am running out of time. So for these reasons, we believe that this order should be vacated and sent back to FERC.
All right, thank
Thank
you.
you.
Thank you to all counsel. The case is submitted.